Good morning, good afternoon, or good evening, depending on where you're at. I'm your host, Bob Mata, and welcome to Defense Diaries podcast, where we continue to watch the breathtakingly weird Laurie SHAVER case. So, a couple of things. One, first of all, it's everybody's favorite murdery weekday. It's Friday 13th. Yeah. Happy Friday the 13th. What better day for all of us true crime weirdos than Friday the 13th? So happy Friday the 13th. And I made an executive decision this morning. Dizzy was talking about kind of the schedule, crack of dawn for Diz. She's like, yeah, charging conference, which is jury instructions. And I'm thinking, okay, that's starting at 8. And here's what's happening right here in our house is I spared all of you having to listen to Hank Hill argue the semantics of the jury instructions. You're welcome. It's still going on. It started at 8. I'll pull it up. We'll have it on in the background. Look, how do I describe it? Jury instruction conferences are critical. They're so very important. However, they are boring as shit. If you're not a lawyer arguing for which instruction you want read to the jury. So I see this as a gift to y'all that we've skipped approximately 50 minutes of it. Because trust me when I tell you this, all of us would have been ready for a full day in the comfort room if we would have had to listen to Wiggs, aka Hank Hill, argue jury instruction. So they're still going. It sounds like what's on the docket today is we're going to have some form of rebuttal case by the state. They always say it. They've slept on it. They may decide that they don't need it. They may decide that they do need it. We'll find out. And then we will shift right to closing arguments. And then, because they're doing the conference, the jury instruction conference now, we will go directly into verdict watch and deliberations. So, and Mandy and Dizzy put together some tasty little tidbits. We'll do some learning this morning. After the closings, we'll look at some instructions. We'll look at the statutes in which we have to figure out whether or not the state was able to prove their case in chief beyond a reasonable doubt in order for the jury to find her guilty. So we'll go through that. And Mandy put together a very nice little demonstrative piece of evidence for us. Evidence as far as Defense Diaries podcast live stream goes. And I think you guys will find it instructive, helpful. So good morning, beautiful humans. It's good to see you again. It's been a fun week. I've loved hanging with all of you. It's been early rising for old Bob over here. Days have gone long. Dizzy, my ride or die, has manned the ship on two occasions. As you know, if you know anything about me, it's family first over here at the Mata House. So when my little girl's playing volleyball matches, Daddy goes and watches. That's that. That will always trump live streaming a trial. So I'm thankful to Dizzy for bringing you all home yesterday. And I forget what other day it was. It was probably Tuesday. She's the best. We all love her. We all know her. She's the Diz. Dizzy is amazing in every single way. And remember, always remember this. If you need just consistent notifications of when we're going live, when Jay's going live, when PB's going live, when Criminality's going live, when Josh at Courtroom Confidential is going live, you go over to the Discord and you find Seeking Justice and you join up there because it's the best. It's far more consistent than the YouTubes, and you're just going to love that channel over there because it has everything you could ever want if you're a law nerd in terms of all the docs. So Tracy and Dizzy just do an amazing job in that Discord. So I highly recommend that you pass go, collect your $200 and go immediately over there and get signed up. You'll thank me. And then you'll be even more amazed at Dizzy and Tracy and the amount of work that they put into this true crime world that we all love so much. You know, it takes a village of just dedicated people that are out here researching, pulling documents. I mean, the amount of work that Tracy and Dizzy do, you guys, is unparalleled. It's not just digging around, it's calling clerks, it's emailing, it's digging up the documents because it's all of it. It's all of it. So I recommend you get over there right away and get subbed or whatever the hell they call it over at Discord. You know me. I don't understand technology. So I'm sure it's a different phrase of becoming a member, Discordian, a justice seeker. I don't know what they call it over on Discord, but we've got one too at Defense Diaries, which is pretty tasty, which of course, you know, I'm fairly certain Dizzy pretty much put together too. I don't even know who built our Discord, but I know it was Mandy, Dizzy, have been instrumental in doing that. But the best in the business is Seeking Justice. That's the spot you need to go. All right, so I'm gonna pull this little puppy up, see what's going on, see what Hank's up to. Uh, Judge, I was thinking that we should probably do the murder two instruction from. It's gonna be something like that. All right, let's see what we got. Yeah, they're still going strong. Strong.
No one is saying that she is guilty solely by failing to report the crime. So there's no
there it is.
to instruct the jury as such.
So, and if you guys don't know what
confusion,
jury instruction conferences are, so essentially they have what they call jury instructions. Okay, and that is the guidebook in which every set of deliberating jurors is sent back into the jury room with in order to begin deliberations. It's their guidebook. It's critical to them to have them back there with them. They have the statutes in there. They have the definitions and the instructions. And if you know anything about the law, and if you watch our channel, and more importantly, if you listen to this podcast right here, this podcast, Defense Diaries, I have taught all of my listeners over there. Basically, I've given, I'd say, about $160,000 worth of law school education in my podcast for free. And I would put up our listeners of our podcast as the most educated true crime consumers out there. And that includes any other lawyer-run podcast because ours are very accurate. I'm objective. I'm not trying to convict everybody. I like to keep it objective. I like to listen to all the facts and evidence and then make decisions on guilt or innocence. And I also realize that prosecutors and cops screw it up sometimes. Just happens. Just happens. So it's best to really kind of dig into all the evidence and then make our decision. So speaking of which, I did go back. I fell asleep to the dulcet tones of uh, Wiggs finishing his direct of his client Laurie, who took the stand yesterday, and then I listened to the state's cross, and I've walked away shy of closing arguments, feeling very much that Laurie Shaver is going down. That's where I'm at with this case. Uh, Listened very carefully to her young 15-year-old's testimony. I listened very carefully to Laurie Shaver's testimony, and I have reached the conclusion that this woman, instead of divorcing her husband, her childhood sweetheart, decided to kill him in cold blood by shooting him in the back of the head. So it's my belief that she will be going downtown to Chinatown. That's where she's going, to the Big P prison. So that's where I'm at. I'm going to do a poll. I'm going to do a pre-closing poll in order to satiate my just incredible desire to know from the people whether or not closing arguments ever have an impact on where my jurors, you guys, where you guys are sitting right now as we move into those closings. I want to see if closings ever change somebody's mind. You know, like I was always the closing guy. Allie was always the opening gal. You know, she usually gave opening statements. I usually did the closings. You know, we were like, oh, the closings are so important. Yeah, look, I think that a vast majority of the time, that people are dead set in what they think coming to closings, and a bunch of silver-tongued words are not changing anybody's mind in closing. So, I mean, maybe on the fencers, which I'm sure there's people that are on the fence in certain cases, right? I'm on the fence a lot. I live squarely on the fence. I'm like Captain Fence Guy, but I'm a lawyer, so I'm looking at things differently. I look at, I look at truly whether or not the state has met their burden, which is a very, very high burden. And sometimes I feel that they just didn't meet it. Here with and as obvious as this story seems, is kind of in your face common sense as this case seems in terms of what went down sometime between November 7th and 10th, 2015. The only thing that adds up is that Laurie did it. So that age-old question we over here at Defense Diaries asked, did she do it? She did it. She did it. That's what happened. She did it. Did she do it? She did it. So that's where I'm at. So, but who cares what I think? I want to see what y'all think. So I'm going to get a poll started immediately. All right, let's just get a poll right up and let's get cracking here. In the meantime, I'll let you guys hear some of the riveting. I mean, I'm fairly certain that Jay wanting to drive into the ocean was born out of jury instruction conferences. I'm fairly certain. I can't be certain 100%, but I'm going to go in like the 98% range. Jay hated, and when I say hated, I mean he hated. He absolutely hated jury instruction conferences. And I would tell them, I'm like, look, dude, Dude, these are critical. These are absolutely critical. I would argue that it could be the most critical period of the entire trial up until deliberations, because these are the words that those jurors have to live by. And words in the law matter. Every single word matters when you're reading a statute. That was why I found our little chat discussion about DUIs, and what constitutes a motor vehicle so fascinating yesterday. Like, somebody was talking like that concept of self-driving vehicles, which are coming. They will be here. Over the road truck drivers are going to disappear because it's going to be robots driving all those trucks. It's like so if it's a computer that's driving the vehicle, I think it's a little bit of a stretch for the state to say that it's a human being operating the motor vehicle. I mean, you're not operating. So I'm excited to see what comes of the law as that develops. Yeah, Kasha, sure. It's like me saying I'll never use AI, and I have fought it. Actually, for my podcast, I had the company that sells my ad space for the podcast, the actual podcast, not the YouTube channel podcast, but my actual podcast, my scripted, brilliant podcast that I hope that everybody's listening to, which, again, I like to remind you all, I like to give you a daily reminder. One of the ways that you can really show, even if you don't listen to the podcast, you get a pretty good idea, even though this is a contemporaneous ad-libbing situation that I do on the YouTube channel. You can only imagine what it's like when I'm scripting, when I'm taking the time to write things out in order to tell y'all a story, how entertaining and riveting my podcast probably is. I like to brag on it because it's great. It's like, it's work that I've done. It's work that I've listened to, and I've compared it to other podcasts out there. So at any rate, I would be incredibly appreciative. It's free to do. It takes very little time. Go over to either Spotify or Apple Podcasts. If you give us a 5-star review, and if you take the time to actually write a little something up, especially if you've lived or if you've listened to the pod. I mean, like, that's what really, like, I don't really want people going over there and writing reviews that haven't listened to the podcast. Now, I do convert via Darren a lot of our lives that aren't trial streams into podcasts, traditional podcast episodes, which are audio only. If you guys have never listened to a podcast, there's no video on that. I think that's coming. That's the wave of the future. But if you've listened to it and you really enjoy it, and if it's brought you some modicum of joy, or I've entertained you, I would be exceptionally grateful if y'all just went over to either Spotify or Apple, gave us that 5-star review, and wrote something up. So, all right, enough of that. Okay, let's go. So I'm going to fire this thing up. Wow, they're still going. Still going. Okay.
All right, thank you.
Hey, that was perfect timing. All righty. Okay, so I'm imagining that they're bringing the jury in, but before that, they might be taking a brief. It's comfort break time. I'd like to invite the attorneys to take a comfort break. Go into the hallway. Give yourself a nice stretch. Maybe some low-key calisthenics. Have a nice sip of water out of the fountain. Shake hands. Kiss babies. Do all the things that you need to do. Oh, did Nook pop in here? That little sweet boy. What's that guy doing? Creeping around. He stands under the fan and all the hair starts circulating. It's like, as much as I brush that dude, no, there's no stopping the hair from falling out. And he's a short hair. Thanks, sweet baby Jesus, because if he was a long hair for as much as he sheds, it would be, whew. Next level. All right. Okay. Poll time. It is poll time. It's poll time. Let's all set up and vote in a poll. Oh, let's go. Oh, you hear that? That's Pass Bob. Just Pass Bob. Oh, wait. I can't close the chat down. Where'd the chat go? How do I bring the chat back? All right. Dizzy, how the hell do I get the chat back up? Where'd it go? I closed the chat. All right. I think I got to refresh maybe. There it is. All right. Let's go. All right. Okay. There we go. There we go. All right. Cool. All right. I am going to create. I'm going to create the poll in real time. Exciting. It's cool. Look at Bob teching. Look at Bob teching. All right. All right. Okay. It's going to be simple. Okay. Now, I always need to make this delineation. Right now, I'm asking y'all, not what you think the jury's going to do. I'm asking you, my beautiful human family, what you think. Is Laurie Shaver guilty or is she innocent? Now, after closings, I'm going to do it again, but then the final poll is going to be what you think the jury's going to do. Because could be very different things. Remember, we can all feel in our heart of hearts that somebody's guilty. However, we can also reach the conclusion that the state, with a very tough case, for as commonsensical as this case seems, you have to keep in mind that the jury may not know and should not know everything that we know. So, did the state put enough together in terms of piecing all of this circumstantial evidence in their little jigsaw puzzle that's going to have holes in it? Did they do enough to convince this jury beyond a reasonable doubt that Laurie Shaver's guilty? All right, so let's get this guy. Okay. I'm not even putting your mom in there, and you know that pains me because we all want yo mamas in there. Okay. All right. Poll is up. Get your oh, God, I love when people come in hot. Mia Beto, thank you. Always giver, all around beautiful human being. Gifted 10 DD memberships. Thank you so much. I appreciate it. I put in a lot of work this week, so I appreciate the support. Yeah, I know, Deja. That's why I couldn't do it. I couldn't do it. Like I want a genuine count of where we stand right now as a team, as a fam. I shouldn't like I'm sure when I said where I'm at on it didn't sway anybody because I'm sure that y'all have your own thoughts on it, but maybe I should have kept that back. I don't know. It's a poll. It's not the end of the world if I've influenced it one way or another. I should have come in with a closing argument this morning of her innocence and seen if I could have swayed anybody. See if I still had it. Oh, Judge. If may it please the court. I'm Hank Hill. All right. So, did you catch how long the comfort break was? I didn't catch it. I'm behind time. It's a fair amount. I mean, I am curious to know whether or not there is going to be a rebuttal case put on by the state, and like try to think about who that might be, who they might recall. Because remember, rebuttal, the boy just ain't right. Uh, the the entire purpose of a rebuttal case is not to add additional evidence like shit that the state forgot. Ooh, I really wanted to ask that question, man. I really no. What its entire point is to rebut directly rebut evidence that was put into evidence by the defense during its case in chief. So I could think of some things. I could think of some things. Like, it would be like, how sweet would it be for the state if they actually had Jeremy Townsend's phone data that showed he was not at that house daily, that he, well, beyond like dropping the kids off for school or driving the kids to school. But I'm talking about like from the 7th to the 10th November, that he wasn't over there. That'd be helpful. Be a home run right there. Absolutely knock it out of the park with that little bits of evidence there. You know, I don't know. I mean, phone data, you can't sleep on the phone data. It's just one of those things where it's what wins cases these days. That's how they crack cases.
Are we ready for the jury?
Hell yeah, we ready.
Yes, sir.
Let's go.
I asked Mr. Coluccio who his witnesses would be.
Wow, 100 votes.
It looks like there's a couple witnesses that have been engaging in social media on this.
Oh Jesus, he's trying to build the motion.
And what are their names?
Well, Mr. Philbrook said his wife doesn't go by.
Do you want the sidebar to go on, or do you want?
Well, I don't care.
Okay.
I want to do it here.
All right.
Well, don't read out the jurors'
There's,
names.
This Philbrook. Right.
Okay, they're putting the jurors on blast here. All right, here's what's going to happen. I'm not going to do it. If I can get to the god dang screen. Bummer. Where's the screen? I'm going to talk right through it so we all don't hear the. All right, dude, listen, don't give out jurors' names. Don't give out jurors' names. It's not cool. It's not cool, fool. All right. I'll keep an eye on that. I don't know why they're doing that. See, that's a law and crime thing. Or actually, Court TV, I think, is the one doing the pool camera. Oh, these are witnesses' names? Sure, spiteful. I thought he said that. Did he say a couple witnesses or jurors? I did hear Wilma, though. So spiteful might be right. Spiteful might be right. Let me see. Let me check it out here. I want to see what he came out sniveling about. Judge? Yep. Spiteful's right. All right. Good. I'm all about it. That we can do because they testified. Thank you for that, Spiteful. Good work. Good work, team. Oh, Oksana. Thank you so much for that $20 hour. Thank you, Bob, for the great nonstop coverage this week. Now let's wish for a great 16th birthday gift for that girl to be freed of that monster of a mother. Hells yeah. And she needs to go, again, without stopping it, go right into therapy to help deal with the amount of horrible shit that's going on in her life so that hopefully she can live a well-adjusted, happy life. I'm rooting for her.
Yes, sir. Let's do that.
Because she's going to need it. She truly is. Oh, shit. I'm wrong all the time. Kidding me? I mean, Leslie knows. I had to stand corrected on the Muppets a mere 2 days ago. I mean, I know when I'm right. Yes. You are a very... Simi, you trying to sell me on the best goddamn chat in the land? I know.
Witness stand.
We have an amazing, the best chat in the
Please be
land.
seated.
I
And
use
let me
you
know when you're
all as a
ready to
marketing
proceed.
tool because you're that good.
Okay, please state and spell your full legal name.
Shut up now.
Please.
R-H-I-N-A, McManus, M-C-M-A-N-U-S.
Thank you. Please raise your right hand. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. And have you yesterday or during this week viewed any broadcasts of the trial?
No.
Okay.
Only like during the weekend when they were picking the jurors on the news, but nothing.
So only over the weekend, okay? But no picking or selecting of jurors occurred over the weekend. That began on Monday morning, okay? But so you did view some broadcasts regarding the case prior to trial,
Just listening to that they were going to pick and this was going to happen, but that's it.
okay? And did you go on social media and post anything concerning the case?
No, sir.
Okay. Did you view anything about the case on social media?
No, sir.
All right. Does the state wish to inquire?
Mrs. McManus, anything that you have seen at this point, would that be news reports about the case?
Not news reports, just like I'm sorry.
Updates.
Just
Court.
stating news over like Channel 9, stating that like there was a trial going to begin, and that's it.
There has been live stream of testimony from this case on Court TV and maybe other sources. Have you watched the testimony of any of the witnesses that have testified?
No, sir.
Mr. Wiggs?
The rule of sequestration was invoked at the pretrial, and the evidence we submitted to the court shows that she has been engaged looking at and discussing the matter with other people on the internet. We believe that is a violation of the rule of sequestration.
Do you have that document? Show that document to the witness, if you would, Mr. Wiggs. It's up here. You may approach.
I don't even remember her testifying. Do y'all?
Yes, sir.
This shows.
Is this Wilma? Who is this?
On a date specific at the top of this, and communications transpiring, correct? Your name is on that document,
Down here, sir?
correct?
Yes.
Okay, and there's discussions about the case on a particular date referenced.
Well, don't leave us hanging. What did she
Correct.
say?
So while this court case was open, the rule had been invoked. There was to be no discussions by any witnesses and no review of social media. When did you look at this?
I did not, sir, but
Okay.
my,
Let me ask, why does it
Yes.
have your name on
because my daughter and my husband, they all use my phone,
it? Okay,
but I did not
Oh.
because I got an email
I mean,
from somebody from,
look. I mean, Wiggs can't talk shit about that. That's his whole defense. It's somebody else. Like anybody could have been using Michael's account. Everybody in the neighborhood knew her Wi-Fi password. It could have been anybody that was, pretending that they were my dead husband sending messages. Stephanie, I can tell you why I have landed on guilty primarily because of the forensic anthropologist or whoever it was. I can't remember. For whatever reason, I have a block against which witness that was, but I believe it was the woman talking about the bones, and who said that there's no way on a double tap, even on a double tap where somebody's just like boom, 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 that a bullet hole is going to, or that one projectile can go directly through the same projectile. Because we then had the stories conflict yesterday, where the state was able to get Isabel to admit that she did in fact shoot him, that he was convulsing, and then Laurie proceeded to get on the stand and say that she saw Jeremy shoot him. So that's 2 gunshot wounds in the skull when we know that there was only the story doesn't add up. Like in a global scale, there's just too many holes. It's like I've seen people talking about, like if Gacy had not given 5 confessions, really they had 0 evidence that he actually murdered any of the 33 people that he was convicted and ultimately executed for killing, aside from the fact that they were all buried on his property. I mean, had Gacy not made those confessions, What's up, Leslie? I was just talking about you. When somebody's like, oh, I think it was Christy said, oh, we love that Bob admits when he's wrong. I was like, I just admitted I was wrong about the Muppets 2 days ago. I ain't afraid. I ain't afraid. But if Gacy doesn't confess, you've got, I mean, what's to say that he's just not charging people, other murderers in the hood, that he's a murderer's graveyard. Yeah. Oh, you kill people? Oh, I got a spot for you. Just dump them here, my God. You know what I mean? It's like, in that case, they have more here. Oh, and I obviously I knew that Jim Henson made both the Muppets and Sesame Street. I didn't know that they referred to Big Bird, Oscar, all the lovable characters on Sesame Street, Cookie, Bert and Ernie, as Muppets. Like, I thought the Muppets was, the Muppets, Gonzo, Kermit, Miss Piggy, Dr. Teeth, the Swedish Chef. So, and I was schooled. Everybody started schooling me. People started digging, and I was wrong. The Muppets did, in fact, predate Sesame Street, and the characters on Sesame Street were referred to as Muppets. So there. I like Muppet Babies is almost too adorable for me. It's like an adorable overload. They're the cutest things. I mean, I think what Muppet Babies has done is created an unfair bar of cuteness for little adorable baby things. All right, so this woman's in shit. So she's basically saying it could have been my husband or son on my social media, texting about the case.
The state attorney saying not to look at that. And that was, I think, on Tuesday or Wednesday, something like that.
And you have abided by that request, correct?
Yes, sir.
Okay. All right.
I think that's sufficient, Judge. The state wants us to assume just because there's an internet browser in this household, nobody else had access it, nobody else could internet it or enter that same site. That's the inference they want to inform the jury about. I'm not satisfied. I'd ask that Ms. McManus be excluded.
All right. Anything further from the state?
Can we excuse, is there going to be any more inquiry of Ms. McManus? Should be excused?
State have any inquiry?
Let me ask.
I have no more. I do have cases in the rule. I'm just, if Ms. McManus can go back outside.
Mr. Wiggs asked for a minute to documents. He may have some additional questions.
Who is this gal? Dizzy, have you figured out who she is? Is this Wilma? Is this the neighbor? I can't remember what she looked like. I mean, are there really trolls on this case? I guess there's trolls for everything, but what's it at, y'all? I haven't looked at let me see what it's at. What's it at? What's it at? Oof. Oh, it's fluctuating. 147 votes, 97% guilty AF, and 3 hell no. She needs to walk. All right, so it's a landslide right now. Let's see if that changes after closings. Let's see if Hank Hill can convince you guys that they simply did not meet their burden.
Wednesday, 11:55 this week, right?
11:55. I don't know. I do have my phone and I can.
My client has her phone record showing that. Judge, I don't.
Rena is this lady's
We know
name.
it's during
Oh,
this
thanks,
week,
Mom.
That's when we found it and discovered it. She's acknowledged.
Yeah.
that
She had like the
She declares we're using her phone.
Farrah Fawcett thing
I'm
going
not
on.
satisfied with that. Yes. And my client has her phone records.
All right. And Ms. McManus has testified under oath that it was not her, but a family member.
Right. That doesn't seem to jive with the state when my client testifies to those same facts, Judge.
I knew he'd make the argument. There it is. There it is. Call that one.
Is there any more inquiry from Mr.
Here,
Anything
let's listen to
further,
that
Mr. Wade?
again. 'Cause it
Same
was,
fact. That doesn't,
McManus?
yes. And my client has her phone records.
All right, and Ms. McManus has testified under oath that it was not her, but a family member.
Right, that doesn't seem to jive with the state when my client testifies to those same facts, Judge.
Is there any more inquiry from Mr.
Anything further, Mr. Wiggs?
No, thank you.
You may step down from the witness stand.
Oh.
Thank you.
that was lovely.
Your Honor,
That-
you have-
Please remain outside the
Bobby?
courtroom.
Did you hear me go in
I do
there and
have
just fool the judge?
Florida statute 90.616, which deals with rule of sequestration, along with Hines v. State 719 Southern 2nd 358. Provide those to the defense and the court.
Nah. I reject Mr. Garrison. I mean, the kind of like a little twangy,
The
but
rule of
Thank you.
sequestration
Down.
only extends to the viewing of testimony. Watching news reports or anything like that is not contemplated by the rule of sequestration. And in Hines, the court points out that the appellant correctly, this is from Head Notes 1 and 2, appellant correctly argues that the trial court erred when it applied the sequestration rule as a strict rule. A trial court must first determine whether the testimony of a witness would be substantially different after having heard the testimony of other witnesses in violation of the rule. Should determine whether the violation was intentional or inadvertent, and if intentional, whether it was the witness, party, or attorney who acted in bad faith. Once it has been determined that the circumstances surrounding the violation, the trial court may then exercise its discretion in deciding whether or not exclusion of the witness is necessary.
Thank you so much, Meg P. $20 holla. Just tipping the Bob Tenda. Appreciate you, Meg. Always give her mod extraordinaire, all the things. And then Elf. Yay. Welcome. Welcome to the fam. Aw, family hug. Thank you so much for becoming a member of DD. We love new family members, don't we, kids? We do indeed.
Case, the testimony of Rena McManus, she is the teacher of Isabel Shaver during the calendar year in question, and she's just going to testify about the child's demeanor, and that there was never any period of time where there was any sort of change. And also I have the school records of Isabel.
No, Simi, this is not the rebuttal yet. They're dealing with some housekeeping issues. Apparently, as attorneys in modern day court cases are known to do, they will scour the internet, scour social media after full days of court and see if there's any shady shit going on. They happen to find a couple of, it sounds like witnesses that testified at trial were active on social media, maybe discussing the case. So that's what they're addressing now. It sounds like they're actually putting the witnesses on the stand. They're doing a little voir dire to see exactly how active they were on social media, what they were saying. So now they're making the arguments. If in fact they do sniff it out and these witnesses were on the stand, and it really only matters if they're on social media prior to testifying, right? Not after. If it's after the fact, then we know that that didn't in any way, shape, or form cloud their judgment and or influence them in terms of their testimony. So that's kind of where we're at now. The rebuttal case has not started. We're handling some witness issues that may have been playing dirty pool. And what is the solution to that if they have, in fact, been creeping around on the socials?
Showing her attendance, her grades, things of that nature. So there's no evidence that she has actually viewed any testimony in this case. Whether or not she or someone in her family liked a post about the case does not warrant exclusion in this case.
All right, Mr. Wade.
To the court, Judge, the data, the information she's looking at is court TV. it's not just a little blog from one person.
Yeah, he
to
does have
another.
some Mr. Garrison in him too,
That shows
for sure.
that she's observing this. But that she's observing the trial matter as it's proceeding. It's not just a little blog from one person to the other. So I believe the witness has violated the rule, then she should be excluded.
The motion to exclude is denied. As to Ms. McManus. Now we're on to Ms. Urbanowski.
Yeah, Lamam, I skipped the wigs portion of it. I want to go right to Laurie. You're talking about the hat in hand begging for legal fees. Yeah, we used that video on our primer. Where you been, Lamam? Sounds like Lamam's been cheating on the fam. That's what it sounds like. I still love you, Lamam.
Good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed.
This witness has a cop vibe. A little bit of a cop vibe.
Are you all set?
And
Okay.
I'll beat your
Please,
ass if you talk
state
shit to
and
me
spell
vibe.
your full legal name.
My name is Rebecca Urbanowski. It's Rebekah. Last name is Urbanowski.
And please raise your right hand.
Interesting.
I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
She's ripped.
Thank you. Please proceed.
Ms. Urbanowski, have you viewed online any of the testimony of any witnesses in this case?
No, sir.
Did you have a Facebook profile?
Yes.
Speaking the
A
mic,
business
dude.
and a personal. Yeah.
And there was a reference, I believe it might have been like on a TV post with your Facebook profile linking the post. How did that come to be?
I'm not sure. I scroll pretty fast when I'm going through Facebook, and a lot of the news channels were covering this. If I might have hit that, then that's my fault. I don't know, but
Even if you were to like posts such of that nature, that doesn't necessarily mean you viewed the video on it, correct?
correct. No, I did not.
Have you viewed any of the testimony in this case?
No, sir.
Nothing further, Judge.
All right, Mr. Wiggs.
Have you been looking at court TV?
I've seen some, not this week. I've seen some, not this week.
That's your name, Rebecca Filmer?
Yeah, it's me.
Okay. And Rebecca Filmer on this one, correct?
Yeah, it's me.
And that says Court TV up there, correct?
Yeah, that says Court TV.
Okay. You go by Urbanowski?
That's my legal name, but I go by Filmer.
Okay. Yeah, we heard different from your husband this week. But this would have been Wednesday?
Oh, that's Travis's brother's wife, right?
This week?
Okay.
Is that correct?
If that's
Yeah,
what
I
it
think so,
says.
Brooklyn.
Is that correct? You think?
You
don't know? Okay. Judge, we'd ask these be admitted into evidence,
It's fine.
and because of the questionable nature,
Well, as far as the hearing, that is fine.
All right.
and because, yeah, correct.
So admitted into evidence as to the hearing only, not as to the trial. And what exhibit are we up to?
I think this would be exhibit 1 for purposes of the hearing.
Purpose of the hearing, it'll be a composite of 3 documents. It'll be defense exhibit A. It'll be entered into evidence without objection as defense number 1 for the purposes of this hearing only.
I don't have any further questions this morning to the court.
All right, and please proceed. Yeah, further questions?
No further questions.
Okay. All right, you may step down from the witness stand. Please remain on standby outside of the courtroom. Thank you. All right, proceed with argument, Mr. Wiggs.
Because of the sensitive nature of the case and the clear instructions of the court to every juror and the obligation.
Hold on, I gotta boost it.
And this matter has proceeded more than once throughout the trial. The state has had ample opportunity to properly advise the witnesses not to be talking. I know the court repeatedly questions the jurors whether or not they should look at, that they don't look at anything. This woman was not responsive and not definitive as to those questions. Yet we have physical evidence that's now in evidence that she has been viewing objects. We ask that she be excluded from this cause.
All right, state's position.
She gave definitive evidence that she has not actually viewed any testimony in the case. That is what would invoke the rule of sequestration as an inquiry. And there has been absolutely no testimony about how that would have impacted or altered her testimony in any way, even if it had been viewed. So therefore, the request should be denied.
Motion to exclude is denied. Is there anything further before we call the jurors back in?
No, Your Honor, not from the defense.
State?
No, sir.
All right, let's bring the jury in. Thank you. All right, please be seated. I see that all of the members of the jury have returned. Thank you again, members of the jury, for your time, attention, and patience today. And I have a few questions for you before we begin. Did any of you speak with anyone or each other about the case? Okay, everyone has answered no. Did any of you view any media, news reports on the internet, anything about the case? Okay, everyone has answered no. Did any of you conduct any research concerning the case? All right, all jurors have answered no. Did any of you encounter or speak with any of the attorneys who are present in this case?
Hey, Sleuthy.
All
Morning.
the jurors have answered no. Anything further from the defense or the state? All right, then the defense has rested. State, you may proceed.
State calls Rena McManus.
All right. Got a rebuttal. Rebuttal case. Here we go.
Good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed.
Oh, you wouldn't have hated it if you heard my Friday the 13th jingle this morning.
Okay, please state and spell your full legal name.
Rena McManus, RHINA MCMANUS.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Please proceed.
Can you please introduce yourself to the jury?
Hi, my name is Rena McManus.
Do you know Isabel Shaver?
Yes, I do.
How do you know her?
She was my student at Pine Ridge Elementary.
And what year was she in your class?
She was in my class in 2016.
Would that be the school year then going from 2015 into 2016?
Yes, it is.
Now, what grade did you teach then?
First grade.
How old are students in first grade generally?
Generally 6 or 7 years old.
And did you know Laurie Shaver?
Yes.
And what about her father, Michael Shaver?
Yes.
And how did you know them?
I had met, they were parents of Isabella, obviously, but I had met them both, meet the teacher, that school year.
And both Michael Shaver and Laurie Shaver attended that event?
For meet the teacher, yes.
And how were they acting during that time?
Normal parents. inquisitive about how the year would be, wanted to find out about me and the curriculum. It was very pleasant.
Now, over the school year that and you were dealing with Isabel Shaver, she had good attendance,
Yes,
good grades,
yes,
and did you ever notice any issues with her?
no,
Was there any time that you saw some sort of behavior change in her?
not at all.
Any time where she appears to become more withdrawn or acted in a different way?
No,
Going to go ahead and at this time admit the records, school records of the children, showing defense states MMM for identification. The state moves into evidence, states MMM as the next numbered exhibit. It's a business record with the proper business record certification and notice.
I believe we're up to 65, correct? Okay, thank you. Any objection?
Judge, no objection.
Without objection, states MMM will be admitted into evidence as states number 65.
And I'm showing witness red number 1205 on the bottom. You recognize these as the records for Miss Shaver while she was in your class.
yes,
And does that confirm everything you've been saying about attendance, grades, no behavior problems, things of that?
not at all. Yes, it does.
Throughout your teaching experience, do you encourage students to talk to you if they have any sort of problems?
Yes, of course.
And did she ever talk to you about any issues that she had at home?
Never.
Did you also teach her brother Aiden?
Yes.
And when was that?
2 years later.
And how was his behavior when you were teaching him?
Just like hers, sweet.
Nothing further, Judge.
All right, thank you. Mr. Wiggs?
How old was Isabel?
7.
7 going on 8?
I'm not 100% particular about her birthday.
Correct. Okay. What degree do you hold?
I have a master's in education,
Anything else?
my teaching degree.
Okay. You have a degree in psychology?
No, sir.
Okay. How large is your class?
Usually from 17 to 20.
Okay. So you're talking about the mindset of Isabel Shaver, correct?
Well, I'm talking about not her mindset, but the behavior that I witnessed.
Right. Okay. And your mind may reflect your behavior to a sense, correct?
Correct.
Okay. Your behavior actually may be shielded by other events in your life, correct?
My behavior?
No, anybody's.
Oh, yes.
Okay. They may want to lock up. They may want to be quiet, correct? Isabel was relatively quiet, was she not?
Yes.
Okay. Do you hold any degree in psychology?
No, sir, I don't.
Any degree in sociology?
No, sir, I don't.
Okay. How large is your class?
It goes from like 16 to 20 students.
How many sit downs did you have with Isabel Shaver on a one-on-one?
Many.
Many?
It's all academic, so we do small groups. So
No, I'm not talking about a small group. I'm talking about you on-one with Isabel Shaver.
in what manner, sir?
I'm just asking you, did you have any one-on-one sit downs with Isabel Shaver?
In processing education, the way we teach? Yes, sir, I did.
You sat with Isabel Shaver individually without anybody else around.
That's not what I'm understanding.
I don't know.
So I have
What?
never.
No, ma'am. Let me ask.
Objection.
Please allow the witness to finish answering. You may finish your answer.
Sitting on a one-on-one in a room isolated, that's not what we do.
Correct. I don't care about what you do. I'm just bringing that point out. You didn't do that.
I think you should care about what I do because I'm a teacher.
Ma'am, I'm bringing out a point.
Okay, sir.
You're not sitting there with Isabel Shaver doing any kind of psychological analysis.
No, sir, that's not my job.
Okay. You don't have a degree to do that, correct?
No, but she's spending more time on a daily basis than Laurie Shaver is with her kid. So I think she's probably got a pretty good idea behaviorally of how Isabella acts on a daily basis.
Correct?
No, sir, and I would not.
Correct.
Thank you.
All right, State.
Mr. McManus, would you have individual conversations with all of your students throughout the course of a year, although other students may have been present in the room?
Yes.
Nothing further, Judge.
Thanks. We have no further questions.
That should be released from our subpoena.
Yes, sir.
All right. Thank you for appearing today. You're released from further testimony. Have a good day.
The state calls Jared Strickland.
This was definitely the best law enforcement officer that the state called.
Good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed. Good morning. All set? Okay. Please state and spell your full legal name.
Jared Strickland, JARRODSTRICKLAND.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Please proceed.
At this point, I'm pretty sure the jury knows you, but can you reintroduce yourself?
Sure. Corporal Jared Strickland, the Lake County Sheriff's Office.
We've been having various discussions about Facebook profiles. The last section I want to cover with you did you view various pictures of Laurie Shaver's child, Isabel Shaver, from November of 2015 through May of 2016 on Laurie Shaver's Facebook?
Yes, I did.
Showing defense was previously been marked for identification as states NNN. Showing the witness was previously been marked for identification as states NNN. Do you recognize those photos?
Yes, I do.
And are those photos from the Laurie Shaver Facebook profile that's already in evidence?
Yes, they are.
Sure. At this time, the state moved NNN into evidence as the next numbered exhibit.
All right, that would be 66. Any objections?
Yes, Judge, a standing objection as to the motion regarding digital data and the relevance issues we've raised previously.
All right, the objection is overruled. States NNN will be admitted into evidence as states number 66.
And Detective, it's easier to just reference the posts from the packet I gave you. Go ahead and publish. Good for you guys. So this first photograph that we are looking at, when was that posted?
November 18th. Actually, November 16th, 2015.
So approximately 6 days, approximately a week after the last known sighting of Michael Shaver.
Correct.
Moving on to the next post. When was this photograph posted?
November 21st, 2015.
have a series of I believe this is about 6 photos. When were these posted?
Are these the pictures with the cookies?
Yes.
November 22nd, 2015.
And that would extend on to the picture that appears to have a gummy worm coming out of her mouth, out of her nose.
I don't know if I'm in order. I see the screen.
Yes. This photo here is part of that same April post, correct?
Yep, there it is. I believe that those are, or the dates are out of whack. It looks like the end of March 2016.
And then the photos here, first of all, this post that starts with page 1828 goes on to the photo of 1829. Do you have a date for the post? Actually, I believe it goes over to, when were these photos posted?
May 3rd, 2016.
Finally, picture of her in the black dress and the post that went along with that. When was that posted?
May 19th, 2016.
Going back to the excavation of the SHAVER residence, were you involved with contacting Ms. SHAVER after the warrant had been completed?
Yes, I was.
And how did you contact her?
By phone.
So she was not in any sort of custody.
That's correct. She was not.
And when you were calling her, what was the purpose of that call?
To let her know that we were finished with the search warrant and that she could return to the house, and also to let her know the items that we had taken.
And at that time, were you asking her any questions, or were you just informing her of those facts?
Just informing her of those facts.
Showing the defense what has been previously been marked as states AAA for identification. Showing the witness states AAA. Do you recognize that?
Yes, I do.
And what is it?
This is a CD copy of the phone call that I made to Ms. Shaver.
How do you recognize that?
It has my initials on it.
And have you reviewed it and listened to it before initialing that?
Yes.
Is that a fair and accurate reporting of that conversation?
Yes, it is.
At this time, the state moves states AAA into evidence. It's the next numbered exhibit.
Is there any objection?
No objection. We just subject to relevance.
Objection is overruled. States AAA will be admitted into evidence as states number 67.
You're going to ask to publish.
Permission granted.
What's going on? I go to make coffee and everything comes to a screeching halt. What's happening?
Hey, sure. Hey, does Laurie happen to be with you by chance? She is. Is there any way I can help her real quick? Yeah, let me see what she's doing. This is Laurie. Hey, Laurie, Sheriff with the Sheriff's Office. Hi. I just wanted to call you review the property that we are done out here. You guys are welcome to come back anytime. Okay. We locked the doors back up. Put the keys off the phone and the shed back where it belongs. And everything is secured. But I do have to real quick and put the paperwork will be left in the house. Okay. To include all the items that we took. If you have to, I would like to just run over the list of items real quick with you or something like that.
Okay, absolutely.
Okay. Total item, cell phone, swab, micro SD card, green
What's swab? What's swab?
most of the swab is going to be stuff that, like,
Swab, things that you swab. Okay, gotcha.
flash drive, a photograph, miscellaneous paperwork, a HP laptop, additional swabs, SD card with photos belonging to Laurie County Sheriff's Office, possible buckshot beatings, projectiles, unfortunately this is a word that I cannot read, and human skeletal remains. So as far as all that stuff goes, do you have any questions?
Yeah.
Okay.
Do I?
Yeah, that was no better for me. Yeah, see, the problem with my Bose, that they're not my headphones that are connected. I won't be able to hear my mic. I'll hear the volume, so it'll get rid of the echo. I just don't have. I need my podcast set up where I have an interface where you plug both your mic and your headphones in, so you hear both through the headphones. I've just got like I don't think it'll work. I could not hear jack shit of what was said. Do you guys want me to try to play that again? I don't know. I don't think it's going to get any better. Like cranking it up will not make that any better. Let's see if he has some questions that helps.
During this phone call, did you inform Ms. Shaver there was human skeletal remains found on the property?
I did.
All right, so I do want to hear that. Okay, so now we know what the topic of the conversation is. The topic is, hey Laurie, we just found a skeleton in your backyard and we think it's your husband. Sounds like shit though.
Hey, does Laurie happen to be with you by chance? She is. Is there any way I can help her real quick? Yeah, let me see what she's doing.
So that was, I think Travis answered. He says, So Strickland calls. He says, does Laurie happen to be with you real quick? And Travis says, yeah, let me see what she's doing. I think that's what was said right there.
This is Laurie.
Hey, Laurie, Sheriff Strickland with the Sheriff's Office.
Hi.
I just wanted to call you know that you over the property, that we are done out here. You guys are welcome to come back anytime.
Okay.
We locked the doors back up, put the keys off their phone in the shed back where it belongs.
Okay, so now he's telling her that we're done searching the property. You can come back anytime. We've locked the doors. We put something back in the shed. So that's where we're at right now.
Everything is in order. But I do have to real quick and put the paperwork that we left in the house.
Okay.
To include all the items that we took. If you have a second, I would like to just run over the list of items real quick with you over the phone and let you know the items that we took.
Okay, absolutely.
Okay? Total item was cell phone, swab, micro SD card, green.
What's swab? What's swab?
Most of the swab is going to be stuff that, like
Oh, swab things that you swapped. Okay, gotcha.
flash drive, a photograph, miscellaneous paperwork.
All right. So what he's telling her about now is what they took property wise, and that they took swabs, DNA swabs from different items.
A HP laptop, additional swabs, SD card with photos belonging to Laurie County Sheriff's Office, possible buckshot TVs, projectiles, unfortunately this is a word that's not read, and human skeletal remains. So as far as all that stuff goes, do you have any questions?
Yeah.
Okay.
Do I?
I didn't hear where he said we found the body.
During this phone call, did you inform Ms. Shaver there was human skeletal remains found on the property?
I did.
Did she react in any way?
No, she just said okay.
Wow.
There was some mention of a computer, some SD cards, things of that nature. Were those ultimately reviewed to see if there was anything relevant about the time frame of this homicide?
Yes, they were.
And was there anything relevant on those various electronic items that were?
There were not.
Nothing further, Judge.
Mr. Wiggs?
Just that, please support.
May it please the court.
Yes, sir. Please proceed.
Deputy,
Corporal.
Corporal, sorry. You were quite polite on that call, correct?
Excuse me, I can't hear you.
I believe you were quite polite on that phone call, don't you?
Yes, sir, I do.
I believe that Laurie Shaver was quite polite on that phone call, don't you?
Of course.
And I don't believe we heard any confession of a crime or any implication of any guilt on that phone call, do we?
To repeat what I've tried to say for the last 2 days.
No, sir.
Whenever you take
No,
all
sir.
of the evidence as a whole,
Sir, please answer the question directly.
As to this phone call, do we hear any confession of guilt?
I didn't ask her.
No. Do we hear any confession of guilt?
No, sir, you do not.
Very well. Thank you.
Thank you. State? All right, sir. Thank you for appearing today. You're excused from further testimony. Have a good day.
Oh, so she's innocent because she didn't confess her guilt. Whew. I mean, it's good to know. It's good to know that people are always innocent when they don't profess their guilt. Moving forward in the true crime world, we will now know. I tried to hook up. These are just like wireless, my Bose headphones. It's not my rig. You need a rig because I need to be able to hear the mic. Like I won't be able to hear the mic in the headphones. And it's really weird if you're speaking on a mic and you can't hear it in the headphones, you're kind of deafened to what you're saying. It's just, I need to go in the basement where Allie usually gets on down there, in order to be able to use my full blown podcast rig setup. Yeah, I've got a very, very nice setup down there, which would probably be more optimal. Ultimately, I'm going to just get when Allie's back full time, which I'm hoping is very, very soon. I think she's done with that thing. I think it's super, super close. So, so we'll have 2 full blown setups. But yeah, I tried. It's just I won't be able to hear myself talk, which is weird.
State calls Kendall Davidowski.
Good morning. Please come up to the witness stand. Please be seated. Make yourself comfortable and let me know when you're ready to proceed. All right, please state and spell your full legal name.
Kendall Davidowski, KENDALLDAVIDOWSKI.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God? Thank you. Please proceed.
Can you please introduce yourself to the jury?
Kendall Davidowski.
Did you know Michael Shaver?
Yes, I did.
How did you know him?
We originally worked together at Spaceship Earth over at Walt Disney World from November of 2014 till about May of 2015.
And what was your position with Disney?
I was an electrical apprentice at the time. He was a mechanic.
And at the point that you met him, where was he living?
He was living at the Warbirds hangar in Kissimmee.
What is that?
It's a airplane hangar. I mean,
And do you know Laurie Shaver?
I know of her. Yes.
And what was, at the time that you met Michael Shaver, well, let me ask you this, at some point did you start a dating or physical relationship?
Yes, we did.
And what was the status of his relationship with Laurie Shaver while he was living at the hangar?
They were separated at the time.
Now, are you aware of what caused Michael to separate and move into that hangar?
I was told.
Based on hearsay?
State response.
Your Honor, can we approach?
Sidebar, please.
Sidebar. Everybody loves a sidebar. I think Kendall here is better looking than Laurie. So, I mean, I don't know why Michael would be wanting to try to get back with Laurie. Just saying. She's an attractive gal. She has the voice of a 13-year-old girl though. It's always disarming to me. I was like, when she spoke, I'm like, wait, how old is she? She's got a young voice. Let's do some shots. Let's do shots. Nice. That was fun. It's good. Got my aerobics in for the day. All the aerobics are in. So as you can see, the rebuttal witnesses are quick, which is typically the case. They're coming in basically to rebut 1 or 2 different points that were made by the defense during their case in chief. Again, rebuttal witnesses are not for the purposes of putting on evidence that you meant as the state to put on during your case in chief. I mean, sure, are they able to get away with it sometimes? Yes. But really what's supposed to be happening is they're directly rebutting evidence that was put on during the defense's case in chief. And as we know, I mean, that was essentially Isabel and Laurie, right? I mean, that was it. It was the story. It was the story. Yeah, no, I definitely know. I definitely know it's not always the looks. I mean, the looks last for about, in terms of like a long-term relationship, I'd say looks rank very, very low in terms of longevity of relationship. In terms of attraction initially, I would argue that they're important, that there's some attraction there. But in terms of longevity of relationship, yeah, looks. But I think we know enough about Laurie and Michael's relationship towards the end that it was not healthy. It was not a healthy relationship. So, um, who called for the sidebar? The state or the defense? Wigs. I think the state did. I think the state did. I have not heard. Somebody had asked whether or not there's going to be a time limit on closings. This is not a case. Look, it was a five. We're on the fifth day, so it was a 5-day trial. These are not going to be hour-long closing arguments. They're probably going to be somewhere in the 20 to 30-minute range each, I imagine. And then, and now, if you're late to the show, I gave everyone the wonderful gift of not having to listen to the jury instruction conference. That went on from 7 my time until just about 8, maybe a little shy of that. So that's done. So it is going to be closings. The judge will, of course, have to read the jury instructions, which we'll have to vote on. We'll have to vote on. If you guys want to hear them, I will, of course, play them. Thanks, rock and roll. Allie, smoke show. She's an absolute smoke show. She is one fine gal. Can't wait till she comes back. I'm super excited about her coming back. It's more fun to have a partner, you know, on here. I miss Jay, but I really, really miss Allie. I mean, she is my best friend. And my wife, and she's brilliant. She's got all the things. She has all the things. All the things. I even love when she interrupts me all the time. It's fabulous. Like, I mean, because she's always interrupting me with brilliant shit. You know what I mean? It's like, who wouldn't want that? Who wouldn't want that in their lives? She's a good one. So, what's up, y'all? What's going on this weekend? Just kill some time here. I'll tell you what, this is Scout's first season of volleyball. It is very intensive. It is practice every day. They have 3 to 4 matches / games per week. And Saturday, we have a full day tournament, which I'm looking forward to. She's loving it. She's doing both travel softball and volleyball. So she's got a very full plate. But I love that she's in athletics. I think athletics are very, very important to forming a lot of important habits for the rest of your life. You know, just loyalty, commitment, good sportsmanship. There's just a lot of positives that come out of sports. So I'm a big proponent of being involved in something if it's not
aware
sports.
of the events that led to why Michael Shaver was living in Workers.
He had told me why he was, yes.
And was that related to his arrest for domestic violence?
Yes, it was.
Now, did he talk? And I'm not going to ask you to say this, what he told you about that event, but did he explain what had happened that night to him?
Yes.
Based on that, did he express fear of Laurie Shaver or his safety?
Yes, he did.
And could you explain that?
He was concerned of his safety and the children's safety with Laurie and a gun.
Laurie and what?
And her having a gun.
Now, Did you ever see Michael Shaver interact with his children?
I saw him interact with his son Aiden once.
And how was that?
They seem to get along very well.
And at some point did your dating relationship with Michael end?
Yes, it did.
And when was that?
About April of 2015.
And who ended it?
It was kind of mutual decision. It was just becoming too much at that point.
And at that point, was he trying to reconcile with the Shaver?
To my knowledge, yes.
Did you remain friends with him?
We weren't friends. We still worked in the same area, so I mean, we were cordial, but we didn't speak to each other.
After he went missing, did you make attempts to reach out to him to see where he might be?
Yes, somebody from Spaceship Earth had contacted me, seeing if I had contacted him or heard from him. I had not, so I reached out to him around November of 2015.
And did you ever hear from him?
I believe he said that he had left and that his children, or he just left the children. But at that point, I didn't know if it was actually him or not.
You and Adam, well, first of all, was that a phone call?
It was through Facebook. It was through Facebook Messenger.
And had you interacted with him in Facebook before?
Previously, before May, yes.
And did you, when you guys were dating, did you also exchange text messages?
Yes.
So was there anything unusual about the contact that you had with him and the content of it?
It just didn't seem like him to just up and leave. He spoke so highly of his children, so I didn't see that happening. And it was very short. It was just all very short, one-word answers. So that was not usually like him.
And have you ever initiated any sort of sexual harassment claim against him?
No.
Nothing further, Judge.
Mr. Wiggs?
You never filed a sexual harassment claim against Michael?
No, I did not.
You know anybody that did?
I had a sexual harassment claim filed against me.
You're sexually harassing people?
Supposedly, yes, according to
Okay.
Disney.
How long did you date Michael?
From about, I would say December of 2015, December 2014 to April 2015.
So you heard Michael's version of events,
Yes.
correct?
Yes.
Did you see any did he show you any photos of any battered women?
No.
Okay. Did he show you any police reports involving Michael Shaver? Okay. Did you ask him about that?
We had a brief conversation about it.
Okay. Did you ask him about any involvement with law enforcement or any agencies?
No.
You know who killed Michael Shaver?
I do not.
Thank you.
Redirect?
Ms. Kavanowski, was anyone involved with this case involved with making that claim against you?
According to Disney, it was Laurie Shaver.
Nothing further, Judge.
Oh, that's
Thank you for appearing today.
amazing.
You're excused from further testimony. Have a good day.
Oopsies.
The state calls Robert Sellers.
That was a priceless moment. That was amazing. Oh, Laurie's calling in and making sexual harassment claims against Kendall. Wow, that was unexpected. That
Good morning.
was in
Please come
fact.
up to the witness stand. Please be
Nice-
seated, make
nice
yourself
little
comfortable,
twist.
and let me know when you're ready to proceed.
Yeah, I can just tell you, Leslie, the bees can't. Now, we need our bees. I never want to hear about anybody killing bees. We need the pollination. It is critical for human beings to exist on this planet that the bees continue to pollinate. That being said, like the orchards we go to are like full blown apple orchards. They have 10, 15 different types of apples. They like pimp it out for Halloween. They've got like the corn maze, all kinds of activities for the kids. It's a lot of fun. And I think I don't know what they do, but I've never had a bee issue at our orchards. But you know, we're kind of out in the country a little bit out here. So but I've never had the bees. I could see a shit ton of bees flying around you, not being very pleasant though. But I am a big bee fan. I'm a big bee fan because of how important they are to us as humans to exist.
Ready, sir.
All right, please state and spell your full legal name.
Robert Sellers, Robert, last name Sellers, Sellers.
Please raise your right hand. I'll swear you in.
I go by Bobby. My friends call me Bobby.
Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. Please proceed.
Please introduce yourself to the jury.
My name's Rob Sellers. I'm currently an FBI agent. I was a Lake County Sheriff's Office deputy for 5 years, and that's how I'm involved with this case.
In 2014, what was your position with the Lake County Sheriff's Office?
At that time, I was on road patrol, assigned to Sector 3, which is the southern portion of Lake County.
And what will your duties be as someone on road patrol?
I'm as road patrol, just like the guys and gals that are on the street now, responding to 911 calls and answering calls for service in the southern portion of the county.
Now, did you have an opportunity to come into contact with Laurie Shaver and Michael Shaver in September of 2014?
Yes, sir, I did.
Were you the arresting officer of Michael Shaver from the domestic violence incident that has been discussed in this case?
Yes, sir, I was.
And when you got there, did you speak with both Laurie Shaver and Michael Shaver?
I did. I spoke with Laurie first and then ended up making contact with Michael a little bit later on.
It's fair to say that their stories contradict.
Yes, sir.
Now, were there photographs taken of both Laurie Shaver and Michael Shaver, along with some things that happened, conditions within the house?
Yes, sir. I believe Deputy Suttles took those photos.
I'm showing defense, which has been previously marked as states QQQ.
All right, sidebar, please.
Sidebar, sidebar. Everybody loves a sidebar. It's been a heavy, heavy, heavy sidebar trial. And we've all been wasted the whole time. Yeah. All right, here. I'm putting this little message up here. There you go. Guys, just feast on that. Oh, honey's magical. Honey, it's got many, 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 many uses. We do indeed need bees to live, Spitfire. It is critical. That's what the pollination thing's all about. Without bees, there's no other creature on the planet that will pollinate. Of course, we have the wind. That's helpful, but nothing beats bees. Need to pollinate. Hot cops. Hot cops. Everybody loves a hot cop. I'm trying to remember, did we have we had a hot lawyer. Had a hot lawyer in this. Good old the attorney ad litem. She was pleasing to the eye. Oh, let's see. Oh, Christy makes a nice apple crisp. Love it. Love it. I mean, who doesn't love that crunchy topping? It's just so delicious. I'm a big cinnamon guy, though. It always stuns me when people are like, I hate cinnamon. I'm like, what? What's wrong with you? It's like I can never like Jay hates everything. Jay hates all delicious things. I think do I remember? Does Jay hate cinnamon? I can't remember. Apple crisp is delicious. It's so good. Topping's the best. All right, let's see what they got.
Showing witness, what's been labeled as states QQQ. You recognize those photos?
Yes, sir, I do.
And what are those photos?
Those are photos that were taken the night of September 4th when we responded to, I guess the first couple photos are from when we met Laurie Shaver in the Target parking lot in Claremont. And then the last couple photos appear to be when we met Mr. Shaver at the residence and photos of the residence itself in Claremont.
Do they fairly and accurately depict the things that you had photographed as part of your identification in this case back in 2014?
Yes, sir, they do.
The state moves to states QQQ for evidence is the next numbered exhibit.
All right, Mr. Wicks, without objection. Without objection, states QQQ will be entered into evidence of states number 68.
go ahead and publish. Move this back to the stage. This photo number 1 from states QQQ. Who is that?
It's Laurie Shaver.
Photo number 2. What does this photo depict?
The photo of her left arm,
Photo number 3.
her right arm.
And photo number 4. Who is this?
Mr. Shaver.
And during the course of your investigation, did you observe any sort of laceration to his head?
Yes, sir.
Photograph number 5. Does that demonstrate that laceration?
That would be the laceration, yes, sir.
And photograph number 6. What is depicted here?
Their residence.
Photograph number 7. What is shown in this photograph?
Broken door to their residence.
Did Laurie Shaver give you any explanation about how that happened?
I don't recall.
Photograph number 8. What is that photograph?
I believe it's the other side of the same door.
Photograph 9.
2 firearms that were involved in the altercation.
Photograph 10.
Be the bathroom.
Was that all the various areas of damage that occurred?
Yes,
That you took photographs of?
the best of my recollection, yes, sir.
There's also some sort of indication of an entertainment center that was damaged. Did Laurie Shaver give you any explanation about how that happened?
Not that I recall.
Any explanation of the broken vase that
Not-
go along with the slide glass door?
There was, but I think there was a story from Mr. Shaver about how that had occurred.
But Ms. Shaver gave you no.
No, it's not that I recall.
Did Laurie Shaver give you any explanation of how Michael Shaver got the injury to the top of his head?
Yes, sir, she did.
And what was that?
She stated that Michael had the pistol in his left hand and that they fought over the pistol. And while they were fighting over the pistol, it somehow went up and struck him in the head.
Did Mr. Shaver have contradictory version of events?
He did.
Were there any adult witnesses present when any of this happened?
No, sir.
No. Were there any attempts to talk to any of the children in this case, specifically the oldest child, Isabel Shaver?
There was, yes, sir.
Was she able to tell you anything about what happened?
No, sir.
Nothing further, Judge.
All right, Mr. Wiggs?
We move this thing. Madam Bailiff?
I'm receiving a call out. I apologize.
Agent, when Michael and Laurie were fighting
Sorry,
over
what
the
do you-
weapon,
hey,
she did
please,
not
of course.
murder him,
Yes,
correct?
What do you go by now? What's your,
I go by Rob, but my legal name's Robert. Yes, sir.
okay, I know you're with the FBI now.
Yes, sir.
What's your title over there?
Special agent with the
Special agent, okay. What do you want me to call you? Special agent? Rob, okay. Rob, when this event transpired and you went to the scene, where was Miss Shaver?
She was on her way to the substation in Claremont, and she was told by dispatch to stop where she was at, which I believe was the target located off 50 in Claremont.
Right. Miss Shaver's the one that fled the residence for her safety, correct?
From my understanding, yes, sir.
Correct. Miss Shaver's the one that fled the residence with the children to protect those children, correct?
Yes, sir.
Very well. Thank you.
All right, redirect.
No, sir.
All right, thank you for appearing today. You're released from further testimony and have a good day.
Thank you, sir.
Yes, sir.
State calls Wilman Nicholas.
All right, good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed. All right, please state and spell your full legal name.
Wilma Nicholas, WILMANICHOLAS.
And please raise your right hand and I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth? So help you God.
Yes.
Thank you. Please proceed.
Can you please reintroduce yourself to the jury?
Hi, I'm Wilma.
Now, in September of 2014, was there a disturbance at your neighbor's house, the Shavers?
Yes.
And how did you become aware of that?
When I arrived home from work around 6 o'clock, Mike called me on my cell phone.
Not getting into anything specific that he said, but did you go over to his residence at that point?
Yes.
And when you met with him, how was he acting?
He was kind of frantic, distraught.
Did you observe any injuries to him?
Yes.
What was his demeanor? Was any, he said distraught, anything?
He was really concerned.
Did he still appear to be under the effects of the event that placed him into that condition? Was he still troubled by whatever caused his injuries and things of that nature?
Not so much of his injuries as something else.
Just for the record, I'm going to object on Williams' basis under the Williams rule, the matters that we previously addressed at the court.
Yes, sir. State.
Can we approach?
Yes, let's have a sidebar. Thank you.
Sidebar, sidebar. This judge loves sidebars. Yeah, sure does. Sidebar City. All right, little get down. We've had multiple shots this morning. You guys feeling woozy yet? You guys feeling it? You guys feeling the boozy? The woozy boozy. Yeah. See, all these witnesses are quick hits, right? They're all testifying to specific items or occurrences that rebut certain things that were said by either Laurie and or Isabel. So I don't know how many they have to put on. I don't know if Diz has seen the full witness list, because there could be folks, like we've seen multiple witnesses so far that did not testify during trial but have only been called for rebuttal. Wilma here is a twofer. She definitely testified at trial, you know. Oh, good. Feeling the juice, feeling the juice. Fire water.
So while Mr. Shaver was in this excited state, did he describe to you what had happened?
Yes.
What did he describe to you that happened?
He told me that they had had an argument. Laurie was intoxicated and she had taken off with the kids. The injuries that I saw on him, he said that she had threatened to kill the children, him and herself, and he fought her with the gun and was trying to get the gun away from her, and she hit him over the head, the top of the head with the gun.
Did you see injuries consistent with that?
Yes.
Did you take pictures of those injuries?
I did.
Showing the defense what has been previously marked for identification as states 000. Showing the witness states 000. You recognize these photos?
Yes.
And what are those photos of?
Those are the pictures that I took of Michael and his injuries and his torn clothes.
Does that accurately reflect how Michael Shaver was when you observed him that night after you described the events that you talked about?
Yes.
This time the state moves states 000 into evidence. This next numbered exhibit.
Mr. Wiggs, any objection?
Same objection, Judge Standing.
Objections overruled. States 000 will be admitted into evidence of states number 69.
The time frame that you knew Mr. Shaver, what was his approximately height and weight?
He was about 5'6", almost the same height, I think, as me, and about 150 pounds.
Going to go ahead and publish photograph number 1 from the previous exhibit. What were you trying to show with this photo? Can you see it?
Barely.
Let me turn it.
Okay. You can tell that he has blood coming from the top of his head, and it's come down onto his shirt. His shirt has been torn in multiple areas here in that photo.
And the tearing of the shirt, did he attribute that to Laurie Shaver?
Yes.
5'6", 150. Wow. He's a small guy. Laurie's pistol whipping him. Jeez.
Photograph number 2.
Here you can see the top of his head and the injury a little bit better here.
Did you take a top view of that in photograph number 3?
Yes.
Photograph number 4, what are you showing here?
He had the keys to her truck in his pocket, and she was fighting him and tore his shorts to get the keys out, and she succeeded in getting the keys out.
And did he express why he was trying to prevent her from having those keys?
Because she was drunk and she was taking off with the children.
Nothing further, Judge.
All right, Mr. Wiggs.
Hey, please, court.
Yes, sir.
Do you know who was charged out of this incident with any criminal offense?
Yes,
Who?
Mike was.
Correct. So you get Michael's version of the events, and only Michael's version, correct? Correct, ma'am?
Yes,
And Michael ends up being prosecuted, correct?
he does.
Okay. So you would agree the state attorney's office had a different opinion.
Objection, Your Honor. Charging decisions of the state.
Sustained.
So evidently, people were dealing with Michael Shaver. Michael Shaver ends up prosecuted, correct?
Based upon,
Ma'am,
yeah,
correct?
yes.
Okay. So what you got is a one-sided interview with Michael, correct?
I have heard her myself.
No, ma'am. You spoke to Michael, correct?
Yes.
Okay. Did you interview Laurie Shaver?
No.
Okay. Do you know who the initial aggressor was that caused that injury to Michael Shaver other than what Michael Shaver told you?
I wasn't there in person.
Correct. Correct. Thank you.
All right, redirect.
Yes, sir.
All right, thank you for appearing today. You're excused from further testimony. Have a good day.
The state calls Rebecca Urbanowski.
Let's see if we got some.
Dan? All set? All right, please state and spell your full legal name.
Rebecca's back.
It's Rebecca Urbanowski.
Still?
REBEKAHURBANOWSKI.
All right, thank you. Please raise your right hand and I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please proceed.
I am Rebecca Urbanowski.
And do you know Laurie Shaver?
Yes, I do.
How did you meet Laurie?
I met her at the gym through her boyfriend at the time.
And did you work for the gym?
Yes, Gold's Gym in Claremont.
And what position did you have there?
I was a personal trainer there.
And when you
Boom. Somebody nailed it in chat. You know who you are. I can't remember who it was. Somebody called that.
say her boyfriend at the time, who was that?
Jeremy Townsend.
Did you ultimately start a professional client-trainer relationship where you were training her?
Yes, I did.
And what was her general physical status at that point?
She was in pretty good shape. She had lost a substantial amount of weight on her own already, but she was in good shape, better than most, new clients that I get.
Was she doing strength training?
Yes, we train twice a week.
And do you know Travis Filmer?
Yes, I do.
How do you know Travis?
That is my brother-in-law now.
Who's your husband?
My husband is Austin Filmer.
And when did you get married to Austin?
October 28th, 2016.
Now, did you legally take his last name?
I did not.
So on your driver's license, it says Rebecca Urbanowski.
It still says Urbanowski, yes.
Have you ever had any sort of social media profile where you had the last name?
Yes, I have, yeah.
But if it were said that you never took his last name, that would be a correct statement.
Legally, no, I never took it.
Did you ever socialize with Laurie Shaver and Travis Phillips?
Yes, I did.
And when did they start dating?
I don't know a specific date that they started dating, but I know that they were in contact after they had initially met and hung out.
When approximately did they start hanging out?
They met the first time at the end of February of 2016.
And when was this compared to when she was dating Jeremy?
It was kind of in like that gray area, I think. When Travis and Laurie first met that night, Travis had already had a girlfriend at the time. So after that night, they actually left. We had gone to Old Town, and Austin and I were kind of dating at the time, or starting to date. And both the boys came, and Laurie and I had been there. And when Austin and Travis showed up, Travis felt it was uncomfortable because he had already had a girlfriend at the time. He didn't want it to look like a double date. So they left probably 20 minutes after getting there.
The period of time when she was dating Jeremy, was there like a hard break to that? And then Travis came to the picture, they kind of overlapped. What was the deal there?
They kind of felt like they overlapped. So it was kind of a gray area where when one stopped and then the other one officially began.
At some point, did you live with the defendant?
Yes, I did.
And is that at the residence in Claremont?
The Sandy Pines, correct. Yeah.
And when did you start living with her?
That would have been May 7th, 2016.
And at any point while you were there, would Jeremy come over, stay overnight, or anything like that?
Never overnight. I've only seen him there one time when I was there, but I hadn't moved in at that point.
And like, what kind of day are we talking about when Jeremy would come over?
It was during the day, during the afternoon time.
Around your lunch break?
Yeah, I would say so. Yeah.
And while you were living there, did you see Laurie with multiple phones?
Yes, I did.
And what was her phone number at the time?
Offhand, I can't say exactly what it was. I just have the one that I have now.
Is that the same number that you had back then, or has that changed?
It would have changed.
Okay.
Yeah.
Now, during the time that you were friends with Laurie Shaver, was a concrete slab put in the backyard around a fire pit?
Not when I had initially moved in, no.
But were you friends with her and socializing with her when that occurred?
Oh, yeah, sorry. Yeah.
And were you and Austin present when the cement slab was placed down?
I was actually at work most of the day. When I got back, it was there because I worked majority of the day.
During the time frame that Laurie has been with your brother-in-law, Travis Phillips, has the relationship between Austin and yourself changed with Travis?
Very much so.
Describe.
We rarely see Travis anymore. For a while, we couldn't even get in contact with him because we found out that all of our phone numbers were blocked from his phone. Austin and Travis have always been very, very close. They're fraternal twins, and they've been through a lot in life together. They used to go fishing a lot, hanging out, but we don't see anything from him, or we don't talk to him. We don't socialize. The last time I've actually physically seen him was when their grandfather passed away at his funeral. That was the last time I physically saw him.
Did Laurie Shaver ever tell you what happened to her prior husband, Michael Shaver?
Just that he had left.
Nothing further.
Mr. Wiggs?
So y'all have a bad relationship.
Who?
Austin and Laurie and Travis, correct?
There is no relationship.
Correct.
Sure.
So that's what you have to testify here to tonight? That there's a bad relationship? Bad blood?
I guess.
You lived in the residence in a certain period of time, correct?
Correct.
Didn't see a homicide committed there, did you?
No, I didn't.
Didn't see anybody being buried, did you?
No, I didn't.
Okay. And you know there was, she was dating Jeremy for a period of time, correct?
Yeah, for a little bit.
You have sit downs with Jeremy?
I've seen him once there.
Okay. So he was at the house once. You moved out. What was the time period you moved out?
It was the day after their wedding. So it would have been 2008, January 1st, 2000.
You're talking about Travis and her.
Yeah, Travis and Laurie's wedding, yeah.
So were you back there when the period of time when you was dating Jeremy?
Was I back there? What do you
Were
mean?
you living with Laurie?
When I moved in May, they weren't really dating. It was kind of an up and down.
Thank you.
Redirect?
The wedding that you referred to, that was in, what year was that?
That would have been December 31st, 2016, sorry.
And had that been you were a guest at that?
Yeah, because we were the next day, we were moving into, Austin and I and Kendall were moving into our new home.
Had that event been represented to you to, in fact, be a wedding?
Yes, it was.
And she was in a white dress?
Yeah, when I had come back from signing our lease and everything, she was already in her dress.
There was wedding cake?
There was a wedding cake, yep, a dress.
Everyone there thought that Travis and Laurie were being married at that time?
For sure.
Nothing further.
All right, Mr. Wiggs? Nothing. All right, thank you for appearing today. You're excused from further testimony. Have a good day.
The state calls Katina Vasquez.
Man, they had a lot of witnesses lined up for rebuttal. Yep, no, defense is done, Bigley. They are done putting on evidence. This is it. It'll go rebuttal, jury instructions read to the jurors after closings, and then deliberations.
All right, good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed. All right, please state and spell your full legal name.
Katina Vasquez, Katina V as in Victor, Asquez.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God? Yes, okay. Thank you. Please proceed.
Please introduce yourself to the jury.
Hi, I'm Katina Vasquez.
And do you know Laurie Shaver?
Yes, sir.
Do you see her here in the courtroom today and can identify her by something that she's
A black jacket.
And how did you meet Laurie Shaver?
Through Scott Amatuccio, my ex-fiance.
And do you remember approximately what year you would have met Laurie Shaver?
I believe we started dating 2006, 2007, and we ended the December 2014.
And did you know Michael Shaver?
Yes, sir.
And how did you meet him?
Through Scott.
And were Scott and Michael Shaver close friends?
Yes.
What was your through meeting Laurie through her friend Mike, did you develop a friendship with her?
Yes, sir.
Did you develop a friendship with Michael Shaver?
Yes, sir.
Closer friends with her than Mike?
Yeah.
And did you ever go over to the Shaver residence after Mike disappeared in November of 2015?
Yes, sir.
And why were you going over there?
She said he had left, and I went over just to see how she was doing.
And did Laurie say anything to you about where Mike was?
No, just that he left in a black SUV in the middle of the night.
And did she reference anything to you about Mike's work or whether or not he was still working there?
That I don't think he was going to work.
And did she tell you specifically how he informed his employer that he was no longer going to work for them? You don't remember anything about that?
Mm-hmm.
Okay. While you were there, did you see anything that you thought was unusual based on the story that she gave you that Mike had just left?
Yeah, all his stuff was still there.
When you say all this stuff, what do you mean?
She was in the she was on the porch on the phone, and I went into the bathroom, and like all his stuff was like still in the closet and stuff, and the car was there.
Talk about clothes, toiletries,
Mm-hmm.
things of that nature? Is that yes?
Yes.
Okay. Did you see any extra phones in the residence?
There was a black phone on the counter.
Now, while you were there, was the defendant trying to sell or get rid of any of Michael's property?
Yes.
And what was that?
She was on the back porch on the phone and was trying to sell guns. And I asked, why are you selling Mike's guns? Isn't he going to need them? And she said she bought them. They were hers.
Now, were you familiar with the domestic violence case where Mike Shaver was arrested in 2014?
Yes, sir.
And how did you become familiar with that?
Laurie told me.
And what did she tell you about that 2014 domestic violence case?
At her house, she said, because Mike had come back into the home, he was living at an airport. And she said that, and I was kind of like, why is he here? Kind of. And she said that she was working with being honest with her therapist and that Mike didn't touch her. Like all the wounds were from her. She threw a vase and broke a door. It wasn't Mike, and he was actually trying to stop her because she had a gun and was trying to kill herself.
When did your friendship with Laurie Shaver end?
2017.
And at the time in 2017, when the friendship ended, did she make any statements to you relating to Michael Shaver still being alive?
Yes, sir.
And what did she tell you?
She was going to move up to Gainesville because I had a son and couldn't afford daycare. And she was going to drive up, look for houses. She got my Starbucks order, took pictures of the kids in the car, and then disappeared. Didn't hear from her for 2 weeks. Took me off Facebook. 2 weeks went by, and she finally got in touch with me and said that she panicked because Mike was in the parking lot. And she thought maybe Scott told Mike that she was coming up there and he was stalking her. And I'm like, well, why haven't you called me? And she said that the cops had her phone and the truck was at the police station because he was tracking it.
And this is in 2017 that she was saying Michael Shaver was stalking her.
Yes.
So clearly after May of 2016.
Yes.
And clearly after September of 2016, when the cement slab was put in her backyard.
Yes.
Nothing further.
Mr. Legs?
May it please the court.
Yes, sir.
Ma'am, did you file a letter to support Laurie Shaver on an injunction?
No.
No? You never submitted any letter to DCF?
No.
Did Michael ever obstruct your relationship with Laurie?
No.
Okay. Now, when you said that Laurie was selling property out of the residence, do you have any understanding whether that was only Michael's property or whether it was marital property?
It was.
That she was by law prohibited in any manner?
She just said the guns, and I know the guns were theirs. And
Okay. Do you know anything about marital labor and contribution to the marriage?
no.
Correct. So you just assume this is Michael's property and she had no right to touch it, correct?
They were their guns. He built and restored guns. So
Do you know why the property was being sold?
no.
Do you know if it was maybe the need for groceries and necessities?
No.
Do you know if there was any plan to aid anybody with those funds to escape detection of a crime? Did you ever witness a murder or any event occur at the house?
No.
Now, the event that you spoke about an incident that occurred at the house, a crime, a battery, were you there to witness that event? Correct. Thank you.
Redirect. All right, thank you for testifying here today. You're excused from further testimony. Have a good
She was a
day.
big witness. Low key
Next witness.
huge.
At this time, the state of Florida rests.
Boom. Yeah, I bet you that Hank had that letter.
All right, let's take the jurors out at this point. Have a comfort break.
Oh, it's time for a comfort break. I'd like to invite all of you to go back into the jury room, lay down on the comfort. Yeah, she was big. I think she had even more. I think when we did the primer, I think she was the person that Laurie had said Michael no longer walks this earth to. I'm pretty sure it was her.
Jurors have exited the courtroom. Are there any motions at this time?
Yes, Judge, we'd renew our motion for judgment of acquittal on
Denied.
the same grounds previously stated. We'd also make clear that these acts of violence that have been spoken of have been only offered for prejudicial value against the defendant. There's no probative value. There's no notice. It's not substantive evidence established to prove a prima facie case. It's purely circumstantial. The state supplied the court with case law. In that case law, there's a notation to a 5th DCA decision speaking about any relative probative value can be outweighed by the substantial prejudice that it presents. It should not have been presented to the jury. The digital data that the state relies on is not sufficient to establish causation. It does not establish the nature of the offense. It does not defeat a claim of self-defense. There's been reference to sale of guns. There's no distinguishing that this is non-marital funds, that Ms. Shaver had no right to sell this property, nor does it advance any claim to an accessory after the fact. We'd ask that the court grant a judgment of acquittal on these grounds and all other arguments previously mentioned before the court.
All right, thank you, Mr. Wiggs. State's response?
The state most favorable in the light most favorable to the state, there's sufficient evidence to present to the jury.
Motion is respectfully denied when viewed in a light most favorable to the state. The evidence does establish a prima facie case sufficient to support a conviction as to each count in the information. Motion is respectfully denied.
You tell him, babe. You tell him.
And anything further, Mr. Wiggs?
Nothing further. 1 second.
Yes, sir.
Your Honor, my client has informed me she'd like a do-over, please.
Is there no rebuttal from the defense? How long will the state take to print out the revised jury instructions?
I have a couple questions for clarification. They're done, Your Honor?
Yes, sir.
Some answers for Mr. Wiggs on a few things. The forcible felonies in the self-defense instruction, you wanted attempted murder and aggravated battery?
Correct.
In order to define my needs a little more specific, I'm assuming you want attempted second-degree murder and not attempted murder?
Correct. Well,
Okay.
no, wait a second. I think we've declared, or my mindset is that there is an attempted first on her, by Michael against her. So the elements of attempted first.
Attempted first and aggravated battery?
Correct.
Okay. Do you want the definition or do you want the elements?
The elements.
Yes, sir. Thank you, Judge.
All right. And is there anything further? I will read the preliminary instructions to the jurors when they are called back in.
Rich, how long are you going to put that together?
We need probably about 15 minutes to.
Well, 15-minute break, is that sufficient?
I think so.
Would you like additional time for yourself?
No, sir. I'm good.
15 minutes is good. Okay. We'll plan on a 15-minute break. Yes, sir.
Okay, I'm sorry. Do you want to go direct it? What time do you want to take up closing?
Well, and again, there are no time constraints, but for timekeeping purposes, how much time would the parties like?
Usually shorter than the defense, so I'll defer to Mr. Wiggs how long he thinks he needs.
I'll let the state advance first.
Your Honor, I would probably be around an hour. Worst
Whoa.
case scenario, an hour and a half for both my initial and rebuttal. But usually not very long-winded.
All right. Well, sounds like combined it might be 3 hours.
I would
Yikes.
say, I would, yes, at the most.
And again, please take as much time as you need. Right now it's 10:46. We'll plan on coming back around 11, and I'll read the initial instructions to the jurors at that time, and we can go into the closing at that time. We can break for lunch after. Well, we'll see where we get, and then perhaps after the state's initial closing argument, we'll break for lunch, and then proceed with the defense and the state's second round after that.
Yes, sir.
All right. Anything further? We'll take a 15-minute break.
Right? Man, those are lengthy closings. Ugh. All right. Well, I mean, you got to hear them, right? We got to hear them. All right. So comfort break is on. Let's pull that down. Let's dive into some stuff here. Let's do some stuff. So Mandy and Dizzy were busy preparing some nice little graphics for y'all. Let's take a peek at those. Wow, these are fancy. All right. All right. So let's go through it. We've got the Florida v. SHAVER statutes, sentencing guidelines, and jury instructions. All right, let's start going through it. So the charges, she's been charged with a couple of things. Count one, statute in Florida is 78.
Answer the question you got.
What question?
It's to me about somebody testifying about Facebook.
Let's see. At least so there's a question I have to answer. Okay. First of all, Sinead is not a guy, babe. I feel pretty secure that Sinead might be a gal. Allie, did you see the bit with a witness stating that she was on Facebook with her son? Is that the question, babe? Is that the one you're talking about? Is that it, babe? I'm going to assume that's it. So Allie missed that. That wasn't on the rebuttal. That was who turned out to be the actual first rebuttal witness. And Wiggs had sniffed out, or his client had sniffed out, that that witness or somebody in her household had been on Facebook, made a few posts or comments, and they've ordeered her prior to allowing her on the stand. And she's like, well, my husband and my son, they have access to my account as well. And then Wiggs, being the snarky guy that he is, said that, oh, well, the court has I forget what word he used, has not been vibing or jibing. Like the court has essentially rejected the exact same argument that we're making with respect to Laurie Shaver being on Michael's account, that it could have been somebody else, because the judge had said, well, she denies being on there and says it could have been somebody else. So he fired back with, well, it seems like the court thinks it's okay there, but not okay as far as my client in terms of an argument. But so there's that. All right. Let's dig in. Count one. Under the Florida statutes, 782.04, 2, murder in the second degree with a firearm. The offense date was 11/7 of 2015. Count 2, accessory after the fact to a life felony. And that offense date was also 11/7 of 2015. So this is the statute that the state has to prove each and every element of. Okay. And this is the second degree murder with a firearm, the unlawful killing of a human being. Now, whenever you see, I talk about this all the time, that's where you'll have the proof of life witnesses that get witnesses on the stand that will testify that Michael was indeed a human being that walked the planet, and that he was alive and well at one point, and then he wasn't, which is your proof of death when we get to that. So the unlawful killing of a human being when perpetrated by any act imminently dangerous to another and evincing a depraved mind, regardless of human life, although without any premeditated design to affect the death of any particular individual, is murder in the second degree and constitutes a felony of the first degree. All right. So you guys got that. So state does not have to prove premeditation for second degree. Even though, to be honest with you, I think that, let's see, what did Hallie say? Oh, I see. Well, maybe her son messaged Laurie's boyfriend's wife. She's married now. You talking about Travis? Oh yeah. Oh, maybe her son. You talking about the witness's son messaged? Yeah. Oh, I see what you're saying. You're talking about Jeremy and Vanessa Townsend, and sent the flowers, babe. He also sent don't forget about sending the flowers. Okay. So yeah, the premeditation, even though I think that there's, I mean, like the problem for the state with the premeditation part of it is they really cannot pinpoint what day that Michael was killed in terms of making the premeditation argument. I think it was probably more challenging for them because the state's always going to sit there when they're trying to figure out exactly what charges they're going to bring. And they're going to look at the holes in terms of evidence with respect to being able to prove something beyond a reasonable doubt, and not really knowing, because of the length of time it took to discover Michael's remains. It made it increasingly difficult for the medical examiner, or anybody else for that matter, to determine any kind of time of death, much like they did in Murdoch. They had to really kind of use phone data and social media data to try to figure out when exactly it is that Michael was killed, based on the fact that He was no longer communicating with people that he would typically communicate with on a daily basis, specifically coworkers, especially, and also Kendall. Like Kendall, I don't know if they were still dating at that point, but Kendall certainly it can be Greeny. Um, but again, when you don't know the time of death, it can be. You can form premeditation in a matter of seconds. But I think just in terms of being safe, they felt more comfortable with going with the second degree here. All right. So these are this is the actual instruction, which we'll hear when the judge comes back and he starts reading the preliminary instructions to the jury. So to prove the crime of second degree murder, the state must prove the following three elements beyond reasonable doubt. One, that Michael Shaver is dead. Got that on lock. Two, that the death was caused by the criminal act, Laurie Shaver. That's really the biggest question here, right? And three, that there was an unlawful killing of Michael Shaver by an act imminently dangerous to another. Okay, well, we know that he was shot in the back of the head, so I think they got three on lock. And demonstrating a depraved mind without regard for human life. So 1 and 3 in stone. Obviously, the deliberations with respect to the jury will really focus on element number 2 there. The death was caused by the criminal act of Laurie Shaver. So then they give us some definitions. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is, quote, imminently dangerous to another and demonstrating a depraved mind, end quote, if it is an act or series of acts that, one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and two, is done from ill will, hatred, spite, or an evil intent, and three, is of such nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. So that means that if the intent initially was just to cause great bodily harm resulting in a death, same diff. You get where you need to be as far as the state's concerned. Okay, so there's an aggravating factor, which is aggravation of murder by using a firearm. Okay, so if you find that Laurie Shaver committed murder and you also find beyond a reasonable doubt that that murder occurred with a firearm. A firearm is designed as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. A weapon is defined as any object readily capable of inflicting bodily harm. So if you find that Laurie Shaver committed murder, but you are not convinced beyond a reasonable doubt that she personally used a firearm, then you should find her guilty only of murder. Now, this is the sentence in Florida. So 78 or 782.0402. This is the sentence under that. The minimum sentence for second degree murder with a firearm is 25 years in prison with a maximum sentence of life in prison. The judge may also impose other penalties, such as life on probation or a $10,000 fine. Second degree murder is a first degree felony and is considered a level 10 offense, the most severe ranking under the state's criminal punishment code. Factors that may affect the sentence include whether the defendant has a criminal record, whether the defendant is remorseful or accepts responsibility. It's a hard negative on that one. Whether the defendant has a mental or physical illness or disability, whether the defendant shows a desire and ability to reform, and any past good deeds. Laurie's going to be hard pressed to show any of those at the sentencing hearing. I mean, the one thing, I mean, killing Michael in and of itself is absolutely depraved and evil. But the shit that she pulled after the fact with her daughter is unbelievable to me. It's unbelievable. It's disgusting. It's one of the grossest things I've ever seen. I've never seen a trial wherein you've got a parent that has basically manipulated their child or browbeat their child or fooled their child into thinking that they need to get on the stand in order to save her life. Just goes to what a narcissistic sociopath this woman is. She's brutal. She's brutal. And like I said, and that I say this believing that there was an abusive relationship that predated the event itself. I honestly, I believe that. I really do. Notwithstanding that, divorce them. You're already separated. Divorce them. What happened to divorce? All right, so 777.03 accessory after the fact to a life felony. Any person who maintains or assists the principal or an accessory before the fact or gives the offender any other aid, knowing that the offender had committed a crime and such crime was a capital life, first degree, or second degree felony, or had been an accessory thereto before the fact, with the intent that the offender avoids or escapes detection, arrest, trial, or punishment, is an accessory after the fact. So here's the instruction. So 21.18 accessory after the fact to a life felony. To prove crime of accessory after the fact, the state must prove the following elements beyond a reasonable doubt: that the murder was committed by Laurie Shaver, that after the murder was committed, Laurie Shaver maintained, assisted, aided, or attempted to aid name of person committing the felony, in this case herself. At that time, Laurie Shaver knew that Laurie had committed the murder. Laurie Shaver did so with the intent that Laurie avoid or escape detection, arrest, trial, or punishment. I mean, this one's in stone, right? After the shit you pulled here today. All right. It is not necessary for the state to prove that Laurie Shaver's assistance was successful in allowing Laurie to avoid or escape detection, which it did for years, arrest, trial, or punishment, nor is it necessary for the state to prove that Laurie was convicted. The intent with which an act is done is an operation of the mind, and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. So the sentence for accessory after the fact to a life felony: an accessory after the fact to a life felony is charged as a second degree felony, as opposed to the first degree felony, which was the murder charge itself, which is punishable by up to 15 years in prison, up to 15 years of probation, and up to a $10,000 fine. The offense of accessory after the fact is 2 levels below the ranking of the underlying felony offense. The intent of the accessory is important, and they must have acted to help the offender avoid legal consequences. This could include helping the offender escape detection, arrest, trial, or punishment. Assistance can occur days or weeks after the crime, as long as it's proven that the actions were intended to help the offender. All right, perfect timing. That was it. Great job, Mandy and Dizzy, with that. Love that. Sidebar, sidebar. So when I take her into custody after they come back with the guilty verdict, this is how I want you to do it. So remember, she's been out on bond the whole time.
Okay. I'll find it.
Oh, he needs a swing line stapler. That's what he needs.
Judge, do you have my swing line stapler, Judge? Thank you.
I have some bloops. Bloop, 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 bloop. Bloop, 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 bloop. Oh, bloop, bloop. She's got her headphones on. Bloop, 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 bloop. All right, we're gonna slide. Do a little sliding. Oh, what's the standing all about? Let's see what that's all about. Jury coming in. She's like, yeah. She had the pursed lips. I'm fucked look on her face there.
All rise.
You will bring the jury. You will bring the jury. You will bring the jury.
I bet you do, Akasha. Makes your life just a little bit better.
See that all the members of the jury have returned. Please be seated. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Laurie Lee Shaver, the defendant in this case, has been accused of the crimes of murder in the second degree with a firearm and accessory after the fact to second-degree murder. Introduction to homicide. Laurie Lee Shaver is accused of murder in the second degree in count 1. Murder in the second degree includes a lesser crime of manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Michael D. Shaver was killed by Laurie Lee Shaver, you will then consider the circumstances surrounding the killing and deciding if the killing was murder in the second degree or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. Number 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means, with usual ordinary caution and without any unlawful intent, or when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Laurie Lee Shaver may be found guilty of murder in the second degree or any lesser included crime. Murder second degree, count 1. To prove this crime of second degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Michael D. Shaver is dead. 2, the death was caused by the criminal act of a Laurie Lee Shaver. 3, there was an unlawful killing of Michael D. Shaver by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove that the defendant had an intent to cause death. An issue in this case is whether Laurie Lee Shaver did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and C, there was not a reasonable amount of time for a reasonable person to cool off, and D, a reasonable person would not have cooled off before committing the act that caused death, and E, Laurie Lee Shaver was in fact so provoked and did not cool off before she committed the act that caused the death of Michael D. Shaver. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, you should find her guilty of second-degree murder. Possession of a...
You should not find her.
Yes, sir. I will read that again. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, you should find her not guilty of second-degree murder. Please make that correction. Thank you. Possession of a firearm and discharge causing great bodily harm or death. If you find that Laurie Lee Shaver committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime, she discharged a firearm and in doing so caused great bodily harm to or the death of Michael D. Shaver, you should find the defendant guilty of murder in the second degree with discharge of a firearm causing great bodily harm or death. Great bodily harm means great is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that Laurie Lee Shaver committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime she discharged a firearm, you should find the defendant guilty of murder in the second degree with discharge of a firearm. If you find that Laurie Lee Shaver committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime she actually possessed a firearm, you should find the defendant guilty of murder in the second degree with actual possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to, or may readily be converted to expel a projectile by the action of an explosive. The frame or the receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. To actually possess a firearm means the defendant, A, carried a firearm on her person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. When there are lesser included crimes or attempts in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included offense. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of murder in the second degree is manslaughter. Manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, Michael D. Shaver is dead. 2, Laurie Lee Shaver intentionally committed an act or acts that caused the death of Michael D. Shaver. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Aggravation of manslaughter by carrying, displaying, using, threatening to use, or attempting to use a firearm. If you find that Laurie Lee Shaver committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime she personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find her guilty of manslaughter with a firearm. A firearm is defined as any weapon which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. If you find that Laurie Lee Shaver committed manslaughter, but you are not convinced beyond a reasonable doubt that she personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find her guilty only of manslaughter. Accessory after the fact to second-degree murder. To prove the crime of accessory after the fact to second-degree murder, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, a murder in the second degree was committed by another. 2, after the murder in the second degree was committed, Laurie Lee Shaver maintained, assisted, aided, or attempted to aid that other person. 3, at the time Laurie Lee Shaver knew that other person had committed At that time, Laurie Lee Shaver knew that other person had committed the murder in the second degree. 4, Laurie Lee Shaver did so with the intent that other person avoid or escape detection, arrest, trial, or punishment. The elements of murder in the second degree have previously been given to you. It is not necessary for the state to prove that Laurie Lee Shaver's assistance was successful in allowing another person to avoid or escape detection, arrest, trial, or punishment, nor is it necessary for the state to prove that the other person was convicted. The intent with which an act is done is an operation of the mind, and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence, like any other fact in a case. When there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crime indicated in the definition of accessory after the fact to second-degree murder is accessory after the fact to manslaughter. Accessory after the fact to manslaughter. To prove the crime of accessory after the fact to manslaughter, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, a manslaughter was committed by another. 2, after the manslaughter was committed, Laurie Lee Shaver maintained, assisted, aided, or attempted to aid that other person. 3, at that time, Laurie Lee Shaver knew that the other person had committed the manslaughter. 4, Laurie Lee Shaver did so with the intent that the other person avoid or escape detection, arrest, trial, or punishment. The elements of manslaughter have been previously given to you. It is not necessary for the state to prove that Laurie Lee Shaver's assistance was successful in allowing another person to avoid or escape detection, arrest, trial, or punishment. Nor is it necessary for the state to prove that the other person was convicted. The intent with which an act is done is an operation of the mind, and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence, like any other fact in a case. Justifiable use of deadly force. It is a defense of the crime of murder in the second degree, including lesser included offenses, if the actions of Laurie Shaver constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. Laurie Lee Shaver does not have the burden of proving that she was justified in using or threatening to use deadly force, or that Isabel Shaver was justified in using or threatening to use deadly force in the defense of Laurie Shaver. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using or threatening to use deadly force. The law on justifiable use or threatened use of deadly force in Florida is as follows. Laurie Lee Shaver was justified in using or threatening to use deadly force, or Isabel Shaver was justified in using or threatening to use deadly force in defense of Laurie Shaver, if she reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to herself or another, or the imminent commission of attempted first-degree murder or aggravated battery against herself or another. The elements of attempted first-degree murder are: 1, Michael D. Shaver did some act intended to cause the death of Laurie Shaver that went beyond just thinking or talking about it. 2, Michael D. Shaver acted with a premeditated design to kill Laurie Shaver. 3, the act would have resulted in the death of Laurie Shaver, except that someone prevented Michael Shaver from killing Laurie Shaver, or he failed to do so. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. A premeditated design to kill means that there was a conscious decision to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The elements of aggravated battery are: 1. Michael D. Shaver actually and intentionally touched or struck Laurie Shaver against her will or intentionally caused bodily harm to Laurie Shaver. 2. Michael D. Shaver, in committing the battery, intentionally caused great bodily harm, permanent disability, or permanent disfigurement to Laurie Shaver, or used a deadly weapon. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. I believe there's a typo there as well. Great bodily harm, and after great bodily harm, there is another one as well. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include bruises. If Laurie Shaver was not committing any crime other than alleged murder in the second degree, or any lesser included crimes for which the defendant is claiming self-defense or defense of others, and if she was in a place where she had the right to be, then the defendant had no duty to retreat before using or threatening to use deadly force, or before Isabel Shaver used or threatened to use deadly force. If Laurie Shaver or Isabel Shaver was in a dwelling in which she had a right to be, she had no duty to retreat and had the right to stand her ground and use or threaten to use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent imminent death or great bodily harm to herself or another, or the imminent commission of attempted first-degree murder or aggravated battery against herself or another. The use of deadly force is justifiable if Laurie Shaver or Isabel Shaver reasonably believed that the force was necessary to prevent imminent death or great bodily harm to herself while resisting any attempt to murder her or another, or commit an attempted first-degree murder or aggravated battery upon her or another, or to commit an attempted first-degree murder or aggravated battery upon or in any dwelling house in which she or another was present. In deciding whether Laurie Shaver or Isabel Shaver was justified in the use or threatened use of deadly force, she must consider the circumstances by which she was surrounded at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use or threatened use of deadly force, the appearance of imminent danger must have been so real that the defendant or Isabel Shaver actually believed the use or threatened use of deadly force was necessary. Moreover, to justify the use or threatened use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use or threatened use of deadly force was necessary. Laurie Shaver or Isabel Shaver is presumed to have held a reasonable fear of imminent peril of death or great bodily harm to herself or another when using or threatening to use defensive force that was intended or likely to cause death or great bodily harm to another if A, the person against whom the defensive force was used or threatened to be used was in the process of unlawfully and forcibly entering or had unlawfully and forcibly entered a dwelling, residence, or occupied vehicle, or if that person had removed or was attempting to remove another against that person's will from the dwelling, residence, or occupied vehicle, and B, Laurie Shaver or Isabel Shaver knew or had reason to believe that an unlawful and forcible entry or unlawful and forcible act was occurring or had occurred. The presumption of reasonable fear of imminent death or great bodily harm does not apply if A, the person against whom the defensive force is used or threatened to be used has the right to be in or is a lawful resident of the dwelling, such as an owner, lessee, or title holder, and there is not an injunction for protection from domestic violence or a written pretrial supervision order of no contact against that person, or B, the person or persons sought to be removed is a child or grandchild or is otherwise in the lawful custody or under the lawful guardianship of the person against whom the defensive force is used or threatened to be used, or C, the person who uses or threatens to use defensive force is engaged in a criminal activity or is using the dwelling to further a criminal activity, or a person who unlawfully and by force enters or attempts to enter another's dwelling, presumed to be doing so with the intent to commit an unlawful act involving force or violence. Dwelling means a building or conveyance of any kind, including any attached porch, whether the building or conveyance is temporarily or permanently or mobile or immobile, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night. Residence means a dwelling in which a person resides either temporarily or permanently, or is visiting as an invited guest. If you find that Laurie Shaver or Isabel Shaver, who because of threats or prior difficulties with Michael D. Shaver had reasonable grounds to believe that she or another was in danger of death or great bodily harm at the hands of Michael D. Shaver, you may consider this fact in determining whether the actions of Laurie Shaver or Isabel Shaver were those of a reasonable person. If you find that at the time of the alleged murder in the second degree, Laurie Shaver or Isabel Shaver knew that Michael D. Shaver had committed an act of violence, you may consider that fact in determining whether Laurie Shaver or Isabel Shaver reasonably believed it was necessary for her to use or threatened to use deadly force. In considering the issue of self-defense or defense of another, you may take into account the relative physical abilities and capacities of Laurie Shaver, Isabel Shaver, and Michael D. Shaver. Defendant's failure to report a crime. The state has charged Laurie Shaver with the murder of Michael Shaver. Further, the state has charged Laurie Shaver with being an accessory after the fact. You must understand, no individual has any duty to report the commission of a crime simply because they observed a crime having been committed. All right, it's about 11:30 right now. I think at this time we'll take our lunch break. Parties have anything further, state? Yeah, come on up, please.
I thought he said they were going to do initial state closing, then the lunch break. I feel like he lied. He lied to us, the judge. So, all right. I don't know about y'all, but based on that trial we just saw, based on the theory that the defense has put forth, I am suffering from horrible, horrible cognitive dissonance about the fact that they just read a self-defense instruction. I'm confused.
Instructions that I will read to you prior to breaking for lunch. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation and the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whether the words reasonable doubt are used, you must consider, whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court. 7, has the witness been convicted of a felony or a misdemeanor involving dishonesty or false statement? 8, does the witness have a general reputation for dishonesty or truthfulness? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that their testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give their opinion. However, an expert's opinion is reliable only when given on a subject about which you believe them to be an expert. Like other witnesses, you may believe or disbelieve all or part of an expert's testimony. You have heard the testimony of a child. No witness is disqualified just because of age. There is no precise age that determines whether a witness may testify. The critical consideration is not the witness's age, but whether the witness understands the difference between what is true and what is not true and understands the duty to tell the truth. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Defendant's statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to 1, whether when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get her to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. All right, and was that to the satisfaction of the parties?
Yes, Judge.
Okay. And at this time, is there anything further before we break for lunch?
Nothing from the defense, Judge.
Thank you. All right, we're going to break for lunch at this time. Again, please do not discuss the case with anyone, including each other. I would ask the parties to return to the jury assembly room at 12:45. So that'll give you over an hour for lunch. Thank you.
All right, let's see.
All right, the jurors have exited the courtroom. Is there anything further before you break for lunch? We'll meet back at 1 o'clock.
Not at this time.
All right, then we'll begin closings at that time. Mr. Wiggs, anything further? All right, thank you. We're in recess.
Okay, so I was feverishly making a new live. We are going to take a break. I'm going to see if I can squeeze in my Tony Bruschi interview. I had it scheduled for 1. That's obviously not going to work. I put him off yesterday. So what I'll do, let me jump in and send you all to the new stream. I set that one to start up at noon my time. All right, my Apple Watch is yapping at me, screaming at me, yelling, saying terrible things to me, asking me about scheduling. Oh my God, I finally 23,608. That's fantastic. I was sniveling and whining about us being stuck at 23,500 forever. So thank you guys. Yay. Makes me happy. It's good to see growth. Stagnation's never good. All right, let me jump in here real quick and portal y'all to the new stream. I hope y'all come back. Closings are going to be good. And we're going to go right into closings and right into deliberations. We're not going to have to deal with the whole reading of the instructions. That was obviously just handled right then and there. So it's closings, deliberations, and verdict. We'll have polls, we'll have fun, we'll have good chats. I'll come up with some amazing chat topics that we can just throw out there, and I'll start off like huge. Okay, let's go. Closing statements. Boop. All right, so you guys should all be portaled to the new stream. Just a couple of thoughts. Yeah, you guys check out Josh and I. We recorded yesterday. I think it was yesterday. Josh Ritter and I. Interesting stuff. We got into this case. We also got into the Colt, the school shooting, the parent being charged. For some reason, I'm having a brain fart as to the last name. That was very interesting as well. And just a couple of thoughts before we jet. I wanted to definitely thank Brandy Churchwell, 13th juror. Make sure you're going over there and subbing to her amazing channel and her amazing community. She's been giving me inside dope like the whole trial. And I was sitting here thinking because she messaged me today, and she said that I want to read a few of them. She said that Stacy Shaver. Well, she had asked. She said that Isabel, the 15-year-old, is there. She's sitting on the bench, just a couple of feet away from Brandy. And I asked, does she realize that her mom's about to be taken into custody forever? I said, poor kid, I feel so bad for her. And she said, I don't know if she realizes or not. When you see her, you realize how young that she really is. If her mom gets arrested right at her sweet 16, that would suck for her. It's true. And I said that she's just a kid who's gone through absolute hell. And I had stated, because this is what I started thinking about. I said that I hope that Michael's family steps up for the kids. They have to realize that Laurie manipulated her into testifying. Like I started to worry that the Shaver family, might be salty that Isabel got on the stand and basically was claiming that she had shot her father, and that concerns me because there's two children. I'm not including Travis's kids, but Travis is not the biological father of Laurie's first two kids. So step parents have no claim to kids that are not their biological kid in courts of law. I'm sure that there's some kind of set of circumstances wherein if he was willing to take them on, if no one else was going to do it. But I hope that's not the case. I hope that the family rallies around the kids, knowing that these poor kids have gone through just absolute hell, and is kind of well adjusted as Isabel may have sounded on the stand yesterday, in terms of, because she sounded like a normal teenage kid, right? Like, if you just heard her talking normally, you'd have no idea of the absolute hell that she's gone through, and it's like she lost her father, she's about to lose her mother. And, the level of psychological abuse that she has suffered is unbelievable. It's unbelievable. I cannot think of a situation like this. I've certainly seen plenty of horrible parents that have done horrible things to their children, covering the entire gamut from psychological to physical, but to put your kid through years of psychological manipulation to get them to the point where they're willing to come into a court of law and maybe like have her believing that what she testified to is the truth. She was 7 years old at the time, you know? So all jokes aside, I truly hope that the Shaver family is going to bring these kids in with open, loving arms and you know, that they realize that they need all the love and support that they can get. I hope that they realize that these kids are going to need intensive therapy in terms of being able to move forward in life and having a fulfilling, happy, well-adjusted life. It's going to be a hell of a battle. So, all right. Let's plan on meeting back. I set the portal for the new live for, like I said, noon my time. And good. That's what I was hoping to see, gamer. I hope that that's true. I hope that they're not feeling anything against her. I mean, she's a kid, you know. She was under the spell of just an awful human being, awful human being. Just you know, the depths, the depravity that takes. You know, you expect parents to step in front of a train for their kids, not the other way around. Oh, here, I'm going to sacrifice my kid psychologically and I'm going to throw her under the bus to save my own ass. Nah, she's got to go for a long time. She is going to get hammered in sentencing, I predict, because I am quite certain that the judge is going to be just as disgusted with not only the act itself, but what happened after the fact. It's next level disgusting. It truly is. So, all right, you guys, mods, thank you. I love you. I adore you. To everybody who gave wonderful financial support to us this morning, I appreciate you beyond. Mia Bito with the 10 DD memberships. Oksuna came in with a $20 holla. Meg P, always givers, both of them. Elf, join the fam, welcome. Poppin' Delights with a wonderful message and a $10 holla. Appreciate that so much. Sandy, Wonder Mod, wonderful human being, always giver, all the things. Thank you so much for the 5DD memberships. I appreciate it so much. So much. So, and thank you guys for being here. Go get yourself some food. Go take your dog for a walk. Go do all the things that help you relax. Let's come back. Let's reconvene in about an hour. Hear these closings. Get that jury back in the deliberation room. Let's get a guilty verdict here. Let's get some justice for Michael Shaver. All right, y'all. I love you. And you know, without you, I'm just an old man talking about a whole bunch of cases. See you in an hour.
Hot